Any mention?
I mentioned item 11, my lord. This is, sorry. This is the appeal of the state against the order of the income tax authority, my lord. This is a writ petition, my lord.
Yes.
Item 11, my lord.
Yes.
Lordship may have it after 3 weeks, my lord, because this item will require some hearing, my lord.
Yes. Yes. So 3 weeks on the request of the Advocate General.
Lordship, I beg to mention item number 10. Lordship, this matter may also...
Other side.
No, I am there, my lord. I am for the petitioner.
You are for the petitioner?
Yes, my lord.
And you are for the
income tax.
You have any objection?
No, my lord.
How long?
Lordship, 3 weeks.
If you just
There is an interim order, my lord. Let me continue it, my lord.
interim order to continue it.
Much obliged.
Obliged, Lordship.
Yes.
Item number 1.
Lordship, this is an income tax appeal. It's fixed for admission hearing today. The issue raised by the respondent in the maintainability is only with regard to the delay part, saying that there isn't the condonation application
Where
has not been
rejoinder is
filed.
supposed to
Rejoinder
file a
has already
property.
been filed. my lord.
When?
It was filed long back.
Come on, here. Talk on the file. 1-8.
We've received the copy on 15th July, ma'am.
On that same day, it was filed.
I think some problem with the.
Probably, Lordship. I was informed that
It's not there on record.
I was informed that they had returned it for the time being to e-file it and then refile the physical copy. So,
See, we won't consider his submissions. It's not been filed. That's what you have to say on
Lordship,
eligibility.
then I may be granted at least 2 weeks time
No,
because
we're not granting.
because
now
e-filing.
it's a 260A appeal.
Lordship,
To under 260A.
260A appeal is already there. They
So
filed.
is there? Yes. The thing is that now it's delayed. That's the ground taken.
There is no delay,
There is
Lordship.
no delay.
Because the number of 120 days is counted from the date on which the order is received by the
Let's
appellant.
see the affidavit. What do you have to say? Then the date of knowledge is when?
As far as I remember, received on 28/2/2025.
Chile filed in 120 days. Just filed on
331 days,
Yes.
madam. After a lapse of 331 days.
Lordship, that is from the date of the order. It was received on 28/2/2025.
how do you say that?
Lordship, there was a document which
Where
we have
can
annexed.
you say that? Where we sent a petition? Where we said that you now where we just seen a
Yes,
petition?
in the
where we
memo
said
of
received?
appeal also we have mentioned that it
No,
was received.
do not dear receipt. Why you received on 28/2/25? When it's an inter-party matter. Where is it?
If your Lordship kindly sees page number 1 of the memo of appeal, the cause title.
Not cost title. Yes.
Judgment received on 28/2/2025 and the proof of the
Where's
proof
that?
of the that is
Where's
what
it?
Lordship, the proof of the letter
Where's it?
that letter is enclosed to the rejoinder, and that rejoinder, because of the e-filing, it has been.
You dismissing
Lordship,
your
I'm
application.
Lordship will kindly consider,
You took
because
longer for rejoinder.
Lordship,
It's not on board
my
also.
colleague has had a mouth operation.
Sorry.
She is having stitches in her mouth, Lordship. That is why the e-filing could
If
not
the
be
matter
done.
was filed when? 10th of July. You not be corrected.
The rejoinder affidavit, my lord,
Yes,
it has
you
been,
received copy.
we have received on 15/7/2026.
57, yes. The office note indicates that the rejoinder affidavit has not been filed. Stop. MSP Agarwal today submits that the same been filed, but due to some procedural lapses, the same is not on record. MS Abdatta for the respondent submits that her copy was received since
15 July
15/7/2025.
2026.
2026. Stop. That paragraph. This court also perused the memo of appeal, so where there is a discernible delay of 331 days
331 days.
in drafting the appeal. There's no accompanying application that receives sufficient cause shown for the delay. Only the appeals done dismissed. Yes.
Lordship, may permit filing
Yes, please
condonation
do not,
of
do
delay
not tolerate
application.
this kind of,
Lordship, the
attitude.
rejoinder could not come on record due to bona fide reasons,
Yes.
Lordship. I was not aware.
Yes. We gave enough opportunities. He's been hanging fire for how long for rejoinder? Yes.
Lordship, the appeal
Next
got
time be
dismissed
more
in the
alert, that's all.
meantime.
Yes. Thank you very much. Yes. 2.
May it please, Your Lordship. Lordship, my senior instructed me to seek 3 more weeks in regarding this item
Who's
number
the senior?
2. RK Deepak.
Where is he from?
He's from Imphal, Lordship.
A lot of time, my lord. This is a
You
vote.
don't have any local counsel?
Lordship, I'm doing the local works here in Shillong, and
You're based in Shillong?
yes, Lordship.
Very good. Then you argue the matter next date, okay? What is your name?
Thang Thian Kham, Lordship.
Thang Kiang?
Kham,
Ham.
Lordship.
Yes, Mr. So for the appellant, praised that some accommodation be given as the conducting counsel is not available today. However, he undertakes to argue the matter on the next date if the conducting counsel is not present. Okay. You prepare. How many years have you practiced?
7 years, Lordship.
7 years. Then enough.
Upright, Lordship.
Yes.
Item number 3.
Affidavit filed.
Not yet, Lordship. Affidavit
Affidavit-
in opposition already filed, Lordship. Rejoinder affidavit could not be filed. So I pray for further 2 weeks time,
What's the
Lordship.
matter about?
1026, Lordship.
How many times you sought for rejoinder?
This will be the first time I will be seeking time
Yes,
for rejoinder.
as prayed for the 2 weeks time out for rejoinder.
Obliged.
Obliged, Lordship.
4.
The Medicine Act applicable also. You know, the Special Act is applicable. Special Act applications. Only one subject for one question is put on. Anyway, what is this?
Well, this is an appeal against State's order, my lord. There's a delay in filing the appeal. I'm trying to notice.
Said 24 days.
But here, what happened, my lord, we didn't get the certified copy of the order from State.
Yes.
Took substantial time in obtaining that.
Yes. Heard Dr. N. Mojikal, Leonard Counsel, Senior Counsel, on behalf of the
Applicant.
appellant. Issue notice on the condemnation application. Steps to be taken within
3 days.
3 days, just after 3 weeks. Yes.
5.
May it please. Lordship, I prepared a short note also on list of dates for the convenience of the and the relevant citations.
What is the matter about?
This is regarding GST demand notice which has been challenged. And
My lord, we have challenged this, my lord, proceedings on the ground, my lord, violation of section 73(1), my lord.
It's for hearing now, son? It's for hearing?
yes, madam.
Yes.
We have given a type copy of this lordship directed to give a type copy, an eligible copy. We have given it, my lord.
Where's that?
Perhaps third file, maybe, my lord. It is there on record.
The order?
Order is DRC 01 and everything is given, my lord.
Yes.
Is DRC 01. That is, we are saying there is no so-called notice. Our contention is that, my lord.
Let's see a petition first. So make the grounds.
In it petition, my lord, is an actual lordship will find, my lord, at page 27, my lord. It was not clear, that's why we have given, my lord, its clear copy, my lord.
Oh, yes, that one. Where's the clear copy?
Clear copy, my lord, we have given, my lord, this in the third, maybe third file. I've also said, आपको समझा.
Very good, Giovanni.
Trust me, my lord. Next time. No,
copy.
Clear copy. There is a copy. I'll see.
It is, my lord, running page 25, my lord,
Of the affidavit.
of the affidavit, my lord.
Last page.
It is, my lord, page, running page 25, my lord, is running. Otherwise, this my affidavit page number, it will be page number 9.
I'll say that. You find 23rd June.
My lord.
Original copy.
My lord,
Page number 9.
page number 9, my lord.
Yes.
This is a summary of show cause notice, my lord.
Yes. Yes.
Now, my lord, section 73, the subsection 1 requires there has to be a show cause notice, my lord. And rule 142 says, my lord, that a summary of a show cause will be uploaded in this form GST DRC 01.
Yes.
Now, my lord, our contention is that there is no show cause notice, my lord. There is only summary of.
It's a summary of show cause notice.
It is, my lord, a gist of the show cause.
What is the difference between summary and summary show cause and show cause?
Show cause is issued
Will
under.
it amount to you being given notice?
No, my lord, I'm coming on. This law has been settled by the Guwahati High Court principal bench, my lord, saying that, my lord, a summary of show cause notice cannot substitute a show cause notice under section 73(1), my lord.
You have authority to that.
Yes, my lord, I have authority to that, my lord.
Yes.
Now, my lord, section 73(1) says, section 7.
Yes.
Section 73(1), may I read, my lord? Where it appears to the proper officer that any tax has not been paid or short paid or erroneously refunded, or where input tax credit has been wrongly availed or utilized for any reason other than the reason of fraud or any willful misstatement of suppression of facts to evade tax, he shall serve notice on the person chargeable with tax which has not been paid or so paid, which has been short paid, or to whom the refund has been erroneously refunded, or who has wrongly availed or utilized input tax credit, requiring him to show cause as to why he should not pay the amount specified in the notice along with the interest payable thereon under section 50 and a penalty leviable under the provision of this act or the rules made thereunder. Now, lordship may see rule 142.
Yes. Yes.
My lord, rule 142 says, my lord, notice and order of demand of amount payable under the act.
Yes.
The proper officer shall serve along with the notice issued under section
142.
my lord, of the Central Goods and Service Tax Rules 2017. Perhaps it will, my lord, page number 264F perhaps of the book.
Oh, yes. Yes.
My lord, this sub rule 5, my lord.
142.5. A summary.
Somebody, but then this one start from 142 starts, my lord. Sub rule 1 says the proper officials shall serve along with the notice issued under section 52 or section 73. Our cases of section 73, my lord, or section 74 or 74A or section 76, so and so, a summary thereof electronically in form GST or form GST DRC 01 to be uploaded, my lord. Well, first there has to be show cause notice which specifying, my lord, the charges therein, and summary thereof will be uploaded, will be issued in form GST DRC 01. And now, my lord, here in this case, my lord, your lordship,
Yes.
In our case, my lord, additional affidavit page number 9, my lord, lordship will find a summary of so cause notice. It is in form GST DRC 01 under rule 142(1)(a). And my lord, along with this summary, lordship will find
This
it.
is DRC under GST. This is under DRC 01.
My lord.
Prescribed 142(1).
My lord.
Then
Lordship will see that page number 12, my lord. Along with this DRC, this calculation was uploaded, my lord. Page number 12.
yes,
This is a calculation sheet they have uploaded, my lord.
yes.
And they say if we do not respond in 6 days, appropriate proceeding will be initiated under the act. Now, my lord, these two things were issued to us. Apart from that, there are no other things, my lord. So therefore, my section 73, subsection 1 has been violated, my lord. So my humble prayer is that, my lord, at least, my lord, may remanded by giving the liberty to issue fresh so cause notice and giving us time to respond to the so cause
Who is
notice.
the judgment? Where what
My lord.
judgment you see you have regarding different summary show cause and proper show cause?
My lord.
This is the construction catalyzers.
Yes, exactly, my lord.
Yes. Please hand over one copy.
Yes, my lord. It start from page 36, my lord, and to find conclusion, your lordship will find it page 59. This
Of?
this judgment, I've given a compilation.
Where's the compilation?
Just given, my lord. Start from, my lord.
This order, this is not appealable.
This aspect also dealt with here, my lord, in this judgment.
Why is not appealable?
Well, because, my lord, there was no so cause notice, the provision has been violated. Therefore, court held, my lord, in this case, the appeal provision is there, but since, my lord, the section 73(1) is not there, the so cause notice is not there, the proceeding lapse on
It
this.
must be a show cause in the eye of law. I mean,
My lord.
you cannot qualify the show cause in the eye of law.
Yes, my lord, because Act does not provide so, my lord, because it says summary. Therefore, court held, my lord, a summary cannot substitute a so cause.
Where is that?
Page 59, your lords will find.
A 29A.
Page 59, paragraph number 20, paragraph number 29, my lord, conclusions. May I read, my lord?
Have you given the copy
Yes, I've given, my
to
lord.
the
I've given, my lord.
other side?
Yes, my lord.
Yes. Read.
Conclusion. Paragraph on the basis of the above analysis and determination, this court disposes of the instant batch of writ petition with the following observations and directions. The summary of so cause notice in GST DRC 01 is not a substitute to the so cause notice to be issued in terms with section 73(1) of the Central Act as well as the State Act. Irrespective of issuance of summary of so cause notice, the proper officer has to issue a so cause notice to put the provision of section 73 into motion.
Yes.
The so cause notice is to be issued in terms with section 73(1) of the Central Act or State Act, cannot be confused with the statement of determination of tax to be issued in terms of section 73 subsection 3 of the Central Act or State Act. In the instant writ petition, the attachment to the summary of so cause notice in GST DRC 01 is only the statement of determination of tax. In terms of section 73(3), the said statement of determination of tax cannot be substituted and substitute the requirement of issuance of so cause notice by the proper officer in terms with section 73(1) of the Central or the State Act. Under such circumstances, initiation of proceeding under section 73 against the petitioner in the instant batch of writ petition without so cause notice is bad in law and is interfered with. And therefore, lordship will find, my lord, the
What
liberty.
about the appeal part?
My lord. I'm taking 1 minute, my lord.
See, man. Where the
Sorry, my lord, extremely sorry. That part was not. That part was not dealt. Sorry,
Have you addressed that part?
my lord. My lord, since my lord, this initiation was wrong, my lord. Therefore, the entire subsequent proceeding also elapsed, my lord. That is my submission. And in this, the case which I have relied, my lord, in this case, the court has given liberty and they excluded this period from date of issuance of order till date of fresh issuance of notice was excluded. Liberty was given to department to issue fresh so notice. This is pure question of law which I am raising, my lord. That is why I have come in writ petition, my lord. If this matter is remanded, my lord, it will not prejudice to anyone, my lord. Other
Yes, Mr. Kalsi.
Lordship, kindly have the short list of dates which I have placed before your Lordship. Because
At that point, whether summary should cause
yes, my lord. It
will amount to
captures.
should cause under section
Yes, my lord. I have seen. But the facts are important, my lord, to show that so-called notices were issued. I'll just place the facts and the relevant law, my lord. If you lordship will see, first serial number 1, my lord, 21st August 2024, on form GST ASMT 10 issued by the Superintendent of Taxes for April 2020 to March 2020 under section 61(1), read with rule 91 of the scrutiny of returns. Note the annexed statement at page 23 of the writ provides demand under 3 heads. Petitioner knew the precise case it had to meet, my lord. Serial number 2, my lord. On 21st September 2024, reply of by the petitioner of ASMT, my lord 10. Lordship is concerned with ASMT. Section 61(3) compliance completed. Furthermore, petitioner cannot afterwards contend it was not served or taken by the surprise. 25, my lord. Third, my lord, form GST DRC1 issued by the Superintendent of Taxes for so-called under section 73(1), read with rule 141A. At page 28 of the writ petition below, the form DR is accompanied with so-called notice under BS Automobile Notice 72, my lord. Kindly see page 28, my lord, of the writ petition.
Page 28.
Yes, my lord. And if your lordship will see, page 20 details are there, my lord, and page 28, my lord, after the table, so-called notice is attached. Your lordship will find middle of the after the table.
So according to you, 73(1) and 73(3) is complied with.
Complied, my lord. That is the now, my lord. Kindly see further. The note at page 28 of the writ below the table, the form DRC1 is accompanied with so-called notice under BS 7 under notice 7 and 2, my lord. At page 30 of the writ petition, details are the same as statement and 23. Petitioner specifically responding to this said statement contains on petitioner that so-called was not served is false and not correct, my lord. Now, my lord, on 13 December 2024, date fixed for hearing. Date fixed for hearing in form GST DRC1 under section 75(4) and 75(5). Page 27 of petitioner not appeared for hearing. There is no denial by the petitioner of the knowledge of the date of hearing, my lord. On 28 December 2024, date fixed for submission of reply to form GST DRC1. No reply was submitted by petitioner. Even otherwise, there is no prohibition on submission of reply after hearing, my lord. Because they have said the hearing was first and submission was later, therefore it is not a valid. Now, on 27th February 2025, my lord, the order of Superintendent of Taxes, summary of order uploaded in form GST, passed under section 73(9). Furthermore, it is digitally signed under rule 26.
Determination. Order part, this is 27
yes.
to 25.
Yes, my lord. And then recovery is issued, my lord, on 27th, my lord, page 37 of the writ petition, my lord. Now kindly see serial 8, my lord, very relevant for my lord. On 27th May 2025, expiry of 3 months under section 1071 for appeal to the appellate authority. No appeal filed, no deposit under section 1076. On 27th June 2025, expiry of further 1 month condonable under section 1074. The statutory remedy is irrevocably lost. From this date, petitioner did not avail the remedy. Petitioner is stopped from using the writ proceeding to outcome the time barred appeal, my lord. Now, my lord, 10, serial number 10, my lord. 5th March 2026, recovery notice by Deputy Commissioner of Taxes, recovery officer, including DRC 01D, section 79, page 38 of the petition, your lordship will have. And 31st March 2020, recovery notice by Deputy Commissioner of Taxes, demanding reply. Now on 27th April 2026, my lord, after almost 1 year, my lord, of the expiry, my lord, after almost 10 months, writ is filed, my lord. Now, my lord, my submissions are first. Section 73(1), a notice was served at page 30 of the writ petition. It is signed by Superintendent of Taxes. It states the tax period April 22 to March 21, single head of non-reversal of ITs on credit notes, an amount of IGST, CGST and GST. It directs the petitioner to clarify within 30 days, failing which action will be initiated under 73(1), prescribe no form for the notice. Rule 142(1)(a), summary along with notice, form GST DRC1 at page 20, writ petition records the section under which so-called notice is issued as 73. At page 28 below the table, it records the so-called notice is attached and lists the supporting document, BS automobile notice, and the words are used by officer is notice. Section 75 for hearing, an opportunity of hearing was granted in the office, my lord. Section 75 adjournment, my lord, and 142 for representation to this is uploaded in the form of GST, my lord. So all procedural requirement, my lord, is followed under the law, my lord. Now serial number 2, my lord, your lordship will have. So-called notice under section 73(1) has been served on the petitioner. Petitioner has annexed document at page 30 of the writ petition after DRC 1 notice. The officer described the attached file as notice. See page 28 of the writ petition table. Document at page 30 is in compliance with section 73(1). It identifies the person, the period, the head, the amount, and it calls for within 30 days, my lord. See, my lord, petitioner's own pleading in para 6 admits that DRC1 stated that so-called notice was attached and admits that a statement was annexed, my lord. The figure at page 30 are identical to serial 3 of the statement annexed to the ASMT. At page 23, petitioner replied to very figure on 21st September 2024 at page 25. Petitioner cannot plead non-service. Petitioner knew the exact case. Even otherwise, without prejudice, under section 73(1) requires proper officer to serve a notice. It does not prescribe a form. Rule 142(1) prescribes a form only for the summary. Date of hearing and submission of reply. Knowledge of date of hearing admitted by petitioner, my lord. It is submitted that neither section 73 nor section 75 requires the hearing to be fixed after the date of reply. Section 75(4) is satisfied by grant of an opportunity of hearing. Petitioner did not appear on 13 December. It sought no adjournment under section 75(5). It filed no reply on 21st December 24 at any time thereafter. Prejudice must be shown and none is pleaded by petitioner. Petitioner does not deny the knowledge of date of hearing. Two defenses now as were also examined and answered by on reasons of communication of 31st March 2026 in writ petition page 41. All notices are under carry signature of proper officer. One of the ground was that it was not carrying, my lord. Now, my lord, 5 that has not been pleaded, so I will not argue, my lord. 5. Writ petition is not maintainable. Under section 171 provides 3 months for communication of the order. Section 1074 provides 1 month for 1 further month. Order is dated 27th January 2025. Limitation for appeal expires on 27th June 2025. Writ is filed on 27th April 2026. Petitioner has not explained the delay. Plea at para 8 of writ petition, it was under the impression that matter has been closed, is false and incorrect in having itself replied to notice demanding payment in 7 days. It is submitted writ petition. It is using to overcome the expired limitation, my lord. Now, my lord, the judgment is, my lord, CCT versus Glasgow 2020-19 SEC 681. A writ against an assessment order ought not to be entertained on its sole the ground that the statutory appeal stand foreclosed by limitation. Now, my lord, Kamal Ideal Infotech, my lord, this is the order passed. Lapse GST appeal is not to be reviewed in the writ, my lord. Yes, my lord, I have got this, my lord.
Kamal Ideal?
Yeah, Kamal, yes, my lord. And which is Allahabad High Court has also, my lord.
This is which vintage? This is 26.
Yes, my lord. Kindly have the paragraph 2, my lord. The learned counsel of petitioner submits that material facts disclosing necessary ingredient of invoking 74 of Central Goods and Services Tax Act has not been disclosed, there is no willful suppression of the material facts, and the input credit tax claimed in the return filed in October 2017 has been subsequently voluntarily reversed in the return filed in November 2017. It is also contended that a similar issue is pending consideration before the court in SLP number so and so. 3. We have considered the so-called notice dated 8 September 23 and the assessment order dated 7th November 2 passed by the officer concerned. It is patently clear from the order impugned that the factual matrix giving rise to so-called notice has been elaborately discussed. It was open to the petitioner to assail the assessment order by way of appeal under section 107 of CGST Act. He contends that he was unaware of the order which has been uploaded on the electronic portal. No convincing reason to overlook the electronic communication is offered. That apart, petitioner by his own admission was made aware of proceeding much earlier in 2024 and thereafter approached the High Court belatedly in 2025. High Court had rightly declined to entertain the writ petition as a surrogate to appellate proceeding which the petitioner had not availed and had become time barred. Presently, case stands on different footing, where the so-called notice under 17 had been challenged on the primary facts disclosing suppression had not been stated. In view of the facts, we are not inclined to entertain the special petition, my lord. And this my lord, a lordship will find the next judgment is also in page E at my note. Misra Security Services versus State of UP, my lord. This is also a recent order. Paragraph 2, my lord. This writ petition under 226 of the Constitution, where the writ petition has sought the following relief against identical relief, my lord. And then the Honorable High Court of Allahabad, my lord, paragraph 6 onwards, considers 6, my lord. We are rather surprised and are unable to countenance as to how can the petitioner file their present writ petition at this belated stage merely to bypass the limitation prescribed for filing a statutory appeal under 107 of GST Act. It is to be noted that the said Act provides for filing an appeal in 3 months in case we need not burden the order of the settled law that the prescribed limitation is to be strictly followed in tax law. Suffice it to the Supreme Court in several judgments, my lord. The delay cannot be condoned. All these aspects, my lord, all these judgments are quoted. And paragraph 8, my lord. Apparently, limitations for filing statutory appeal have been lapsed. Petitioner has filed a present writ petition in the nature of appeal as the submission of the learned counsel, but the petitioner has been camouflaged to agitate the ingredients of section 74 of GST Act, has not been made in so-called notice or assessment order, which according to the court is a ground which was very much available to petitioner immediately on the issuance of so-called notice on 4/6/2025. We may note that expeditious adjudication of issue is a hallmark of tax laws. We find that section 107(12) of the Act, appeal before statutory is to be decided within a period of 1 year. However, we find the present matters petitioner has not been a fence-sitter, has not been diligently pursuing his rights, and filed the present after 1 year of issuance of the so-called notice. Most importantly, when considerable time has lapsed for filing an appeal has been specifically prescribed under the law, it is still principle of law that one cannot indirectly, which one cannot do directly, and in any case law does not help or come in rescue of a person who sleeps over a rise is further coordinate bench, my lord. So this in the facts of the case, my lord, and your lordship has also taken a view in my note F, my lord, Jorabat, my lord, the Jorabat Shillong Expressway. Yes. Lordship has already. So my case is that the case is barred by time. Notices have been issued, and I can show that their reply, my lord, they knew about the. If your lordship have 1 page of their reply, my lord. On merit also, my lord.
Which page?
Page, I'll just, my lord, page 25.
Of the writ petition?
Of the writ petition, my lord.
Yes.
Lordship will see the reply which was given to the first under reply of Lord will have this under section 61(3), my lord. Excess ITC claim, my lord. For the tax period in consideration, difference in the ITC claimed as per GSTR 3B and ITC accrual as per GSTR 2A has not been rectified but also reversed in annual return of 2021. Your Lordship has seen in Supreme Court identical plea. Also during the financial year of 2019-20, we have availed less ITC which was claimed in the financial year 2021. The input credit has been claimed on the basis of original tax invoice as issued by registered GST supplier to me on purchase of goods. The payment of same was also made by me within 180 days of purchase. Hence, we have fulfilled the condition as needed to obtain the credit of tax, that has been paid on such purchase in line with 16.4. However, the difference of credit between was filed by us as compared which was reflected in GSTR 2 was due to the fact that supplier in question seems to have not filed GSTR return in time, which led to mismatch. So ITC input credit tax was availed without supply. It is thus evident that since we have fulfilled the desired criteria, for our humble request is to allow the same to us. Non-allowability or based on non-filing of proper GSTR return by supplier will impose an unreasonable financial burden on us, my lord. Unsought payment of interest, my lord. So therefore, to say that the petitioner was not aware of the grounds on which the determination was passed, my lord, hearing was given, opportunity was given, he did not appear in any of the opportunity, he did not raise this issue at any point of time, my lord. Whether writ remedy, my lord, in lapsed appeal would lie, my lord.
In para 10 also they admit that.
Yes, my lord.
The delay in filing returns.
Yes, my lord. And so therefore, these questions could have been gone into the appeal, but the issue is, my lord, that writ remedy, my lord, consistent view of the Guwahati High Court judgments on facts are completely different. There is no question of delay. There is no question of all those issues are not discussed in Guwahati High Court judgment.
Yeah, Madam Mishra.
My lord, on what all the judgments my lord, senior finance relied, my lord, on this, the argument was on merit. I'm not on arguing on merit of the case, my lord. I'm only on violation of section 73(1). Now, lordship will see.
Now, only one thing, Mr. Mishra.
My lord.
In the whatever it is, it's page 31 or something. It says that the show cause notice is enclosed.
Now, lordship will see. That is why I'm coming. Page 30, my learned senior friend is relied upon. This is a statement under section 73(3). But lordship will see. Section 73, subsection 3. Statement is this. This is a statement only.
Okay, firstly, answer one question.
My lord.
Is why did you take nearly 1 year to agitate for any whether? Why didn't you go for appeal? Why did you come to this court after nearly 1 year after the order was passed? You were aware of the proceedings. You filed a reply also.
No, the reply was filed.
What is the reason?
I'm coming.
Can you satisfy this court?
I'm trying.
What are the reasons why you have sought to you have come by writ proceeding? Why? Why didn't you file an appeal?
I'm coming.
If there was a procedural lapse on the part of the authorities, that is not a question of law. That's a question of procedural law which can be corrected in appeal. You understand?
My lord.
And by you saying that it's a question of law means what?
Section 73.
Question of law means what?
If my lord says no, so cause has to be issued in section 73(1).
No, so now, why have you come after 1 year?
I'm trying to satisfy lordship.
If you can't satisfy on that initial query, we are not looking at any other.
No, exactly. Lordship is rightly pointed out, my lord.
Yes.
Now, my lord, the reply which my learned senior friend is relied upon, it was in response to a proceeding initiated under section 61. Section 61 scrutiny was done. Notice was issued under section 61. We have replied.
So why do you come for 1 year? I'm not interested in the proceedings.
After issuance of the demand order, my lord, I'm coming. After issuance of demand order, we submitted a reply, my lord, in 2025 only. Thereafter, my lord, we thought matter is rested. When the recovery initiated, then we come to know that matter has not been rested. That we approach here, my lord. After issuance of the demand order.
That doesn't qualify as a, what do you call it, excuse which can be accepted.
Because, my lord, in this 1 year period, there was no communication from the department.
So you are saying that tacitly you're saying the last ditch effort coming before a court. Correct?
My lord, but question much I have because I'm not telling the order, I'm telling the proceeding itself, my lord. Otherwise,
proceeding you could have challenged it, yes.
I'm telling
from the initial summary show cause which you was served, you should have challenged it at that time, saying that look, this summary show cause doesn't comply with the provisions of section 73(1). If that's your ground, because they are maintaining that no, the show cause been issued.
Because just I'm trying to satisfy lordship. There is one judgment, my lord, which says, my lord, if a thing is prescribed in a particular manner, it has to be done in that manner. Otherwise, otherwise, enacting the section 73 will not be redundant, my lord. Because if act is prescribed in a manner, the things to be done in a manner, It has to be done, otherwise it should not be done. Otherwise, section 73 will be irrelevant, my lord. They will issue a simple letter. They said this is so cause, my lord.
Why have you taken 1 year to come even?
And that is why I am saying, my lord, because
then
after issuance of the order, we submitted a reply. Thereafter, we have not received any communication.
anything else submit, that's all.
That is all. But lordship will,
Order this.
but only one thing, my lord. If lordship permits, my lord, since your lordship in what my senior friend has given a judgment of your lordship, my lord, where some time was given to the, if lordship goes against me, my lord, at least some time so that I can immediately approach the.
But your case on different footing.
Definitely, but I understood. Otherwise, I will be remedialess, my lord. And since your lordship in what my lion's friend has given,
You're sleeping over your rights and
No,
step over whatever remedy you could have imposed.
Moment this recovery was done, my lord, this recovery, we received the recovery, immediately approached, we have not delayed any, the recovery was June 31st of March, we immediately approached, my lord, this honorable court, my lord. And our challenge is a very initiation, my lord, the proceeding, my lord. If initiation is wrong, then all subsequent action goes wrong, my lord.
Can we condone such a delay
In
in the facts of the case?
If required, lordship, suppose if lordship is going against me,
That's its own peculiarity.
if suppose lordship is going against me, I am just making one submission. If lordship is of views against me, and lordship require, lordship may impose me double pre-deposit. Suppose 10% require, I can deposit 50% if lordship permits.
Will not go into any.
Otherwise, my lord, I will not be, my lord, I will be remedialess. I will not go. I cannot, because this tax is not payable from me, my lord. There was a mismatch only. That can be explained. There is not evasion.
That you could have explained before the authority.
Yes, that was explained, my lord. In section 61 proceeding, we have explained.
You should have in the appeal.
No, lordship, no, exactly.
Yes.
But even I am just going down.
You understand limited scope on which you are.
I am going down, lordship, to just to some relief or something may be given, my lord.
Hearing concluded.
Much obliged, lordship.
Yes. Yeah. Which one? Oh. Surprise, okay. No, it's okay. Really.
Item number 6.
1 minute.
Eight, please.
Come.
In 5.
Let me see. Rejecting us from the court. Open the thing there. Just being open. This one. You can take it later. Mr. Fukun, last date I can see in the order that you filed amendment application. Where's the amendment
I
application?
just explained to your lordship what happened.
Where's the amendment application?
Both the amendment applications have been filed. I think they are on record, my lord. On both the matters we filed it.
Where's the miscase then?
Today you filed in the other one also.
No, yesterday only. It was served. And the one on the
I
last
have no
occasion.
objection, my
So
lord.
you file by way of miscase?
Yes, this has been filed by the miscase. We have what two typographical error happened, which my learned friend has pointed out in the affidavit, which they have filed. So those has to be allowed.
To us, my lord, it is not typographical error, but we are not contesting, my lord. The lordship may allow the amendment application,
Just a
and accordingly,
number. That's
because the wrong notification has been challenged in the prayer, my
No,
lord.
I tell you, Lordship, what had happened, that the notifications were two numbers. One was 27, one was 28. Entire pleadings is regarding to the notification which concerns us. Only on two paragraphs and one prayer, instead of 28, it has come to 27, which is a typographical error. That is what I was seeking your Lordship's prayer for that. And if my learned friend has no problem in it,
In
it can be
Lordship,
correct. It's only on the number. Rest, everything is the same. Only the numbers. That's
I have no
Correction,
I will-
even if you file an application,
Yes,
you have to file a fresh application, or you ask your permission to correct it. once
I have filed an amendment only seeking for the correction of that time. Only it.
So,
with that, then fresh petition has to be filed.
if you
amended-
file for amendment, you have to
permit me to
file
file a fresh, I'll
Otherwise,
file.
you can file just
Fresh
for correction of clerical or typographical error.
Yes, that's what I have said in my application, my lord.
It will
I mean,
create lot of
it is
confusion,
only
lord.
related to the number. If your lordships direct me, it can be done through the registry. Otherwise, I'll file a fresh. I will file an application amendment petition.
Whatever my friend said, I have no objection on that.
Whatever your lordships direct us, we'll do it.
But it will,
Even application is handwritten.
I'm sorry, my lord.
Even it's addressed to Jesus is handwritten. This is
Which one?
Salutation was missing in this.
the application. This case also.
I said, I'm sorry, my lord. I think they must have. What is missing?
Salutation, the
Oh, the salutation was missing. I'm sorry, my lord. Must have been a mistake. I apologize for it straight away. I didn't realize it. I didn't see the original being filed.
It was allowed
My
by
apologies.
registry.
My apologies for that.
It was allowed by registry. It was allowed by registry. Handwritten, I guess.
नहीं, ये नहीं आया था वो हाथ से नहीं। हाँ वो रह गया था शायद,
भले
ये वाला रह गया था to be honorable.
Also has to be corrected.
I think signatures and all have been taken. Only thing that was left out, I think. I don't know how the registry has allowed it.
Our registry allowed, yes. That is anyway.
I've said it at para 7, my lord,
Yes.
that the notification number was supposed 28. We have inadvertently written as 27.
Yes. So what should we do? Anyway, we'll just cut short the matter. We'll just make it into an application. Yes, yes. We'll treat it into an application in nature of 152 CPC.
Yes, my lord.
Yes. Miss case number 218/2026. This is an application filed by the Police Amendment Prayer Administrative Petition. The correction or the amendment of correction sought is contained in para 7 of the petition with regard to the
Yes, sir.
notification,
Yes, sir. 20.
with regard to the number of the notification.
27 people.
Which should read as E7E, right? Next paragraph. There is no objection to the prayer made by the petitioner by the
Yeah, two hands.
respondents. Subject court notes that though the application has been styled as an application amendment,
There are two
as
applications,
it
two
was
applications.
only a typographical correction, the same be considered an application in the nature of section 152.
I'm extremely grateful for your loss.
The typographical error is permitted to be corrected in the registry itself in the course of the day.
I'm extremely grateful.
Miss
I
Keith,
just wanted.
stand allowed?
I'm sorry.
Those pause, yes.
Just one small issue, my lord. Your lordships, we file a rejoinder. Would your lordships be kind enough to take the rejoinder for 1 minute? Just 1 minute. I just wanted to show something to your lordship, which is relevant.
No, your
Today's
lordship have.
Thursday.
Lordship fix the matter for argument, my lord.
Thursday.
Thursday, my lord, I have a slight difficulty.
Thursday.
Busy counsel, so
I'm sorry, my lord. I had.
Thursday,
May I suggest, if it is not inconvenience, my lord, 25th, if it is not inconvenience. It's a Tuesday. I think your lordships are going to take it on your Tuesday or Thursday, if it is not inconvenience. If my learned friends also have no problem.
rejoinder, it's noted rejoinder has been filed. This is the man 25th.
Pleadings are complete
August
otherwise.
for further orders.
My lord, may hear it because
Open further orders means we can.
it is open to both.
extremely grateful. Extremely grateful. Both them. Item number 7 also the same.
Identical, same.
Same identity.
But you said a counsel should make a correction in the registry.
Yes, we'll move to the correction right now. Extremely grateful, man.
Hearing 8, item number 8.
Well, this is the matter. We like to withdraw, my lord.
So they have been reinstated, your lordship. There is only one thing. There are two directions. One is to reinstate the service. Another is to pay all the consequential benefit. Para 23 of the
We're not
judgment.
adjudicating, they're withdrawing. So
I'm withdrawing it.
adjudicate, yes. You already got your job back.
Yes, yes.
But
my lord.
A casual employee who's not even employed full time gets.
They are very powerful men.
No, there is a direction also to pay the for consequential financial benefit that with or
You're
that there is a
withdrawing
direction.
writ appeal, so
In this writ appeal, how you can claim?
the writ petition will stand,
My lord.
right? Yes, Mr. SD,
There was a contempt also, my lord. That contempt was dismissed.
this Mr.
It's not
SD, the
dismissed.
counsel for the appellant, please be allowed to withdraw this instant writ appeal. Season
In
objection.
view of his reinstatement.
So in view of the fact that the respondent has been reinstated.
Yes,
into service. So, submissions noted. Matter is disposed of on withdrawal.
Highly blessed.
What's your lordship?
9.
Basic to understand this. What is also in the picture of in the picture of we're taking it as a in the picture of I think 152.
May please your
Yeah,
lordship.
with a copy of SLP.
Malad, we received copy of SLP, but Malad may pass over the matter. Malad, Allah African General had to run to court number 1.
Pass the matter to when? The last matter? Dr. Saraf, we just note that the SLP copy have been furnished by the petitioner. We'll have it on Thursday. Yes. Next Tuesday then, because we'll finish this matter. It's already been heard.
Sir,
Yes.
Wednesday.
19, no, 19th is Wednesday. This bench not available. Yes.
18, 20.
You can take 18, 20 or 25. Okay, 25th, yes. And this is a matter on 20th.
Much obliged.
Any mention?
Yes.
May please, Your Lordship.
Yes.
Your Lordship, I beg to mention item number 31.
Objection, my lord.
Your objection?
Lordship.
Okay, we'll take, we'll call it out, yes.
Lordship, in this matter, Lordship, I'm supposed to bring out or record the report.
We'll call
or
it out.
the records.
We'll call it out. You make your submissions then.
Follow.
Yes.
Objection, my lord.
Yes.
May it please your lordship, I beg to mention item number 36 with the consent of the other side matter.
Yes.
Can be taken after 3 weeks if lordship permits.
Yes.
I will oblige.
Much obliged.
On the prayer of so on the discussion. Yes.
Much.
Yes.
May it please your lordship. Lordship, I beg to mention item number 35, your lordship. The conducting counsel is indisposed. Kindly the matter may come up after 3 weeks,
Who's on
your
the
lordship.
council?
He is Mr. S. Chauhan from Delhi, your lordship.
What's the matter about?
It's about land documents here, lordship.
What land
Your
documents?
Lordship, they are seeking, they have come to court seeking direction to the respondents to issue the land records which they have stated to have misplaced, Your Lordship.
Misplaced, yes, your honor.
But however, Your Lordship, that land that they are seeking for, Your Lordship, has already been transferred to a third party. So, Your Lordship, here nothing remains. They
You
will
know
have to
that,
challenge
yes.
that.
Okay. Then after 2 weeks,
Yes, your lordship.
you took.
Deeply
seek
obliged, your
something.
lordship.
Obliged, Your Lordship.
Yes.
May I please, Your Lordship? I beg to mention item number 40, Your Lordship. The conducting counsel is indisposed, Your Lordship. That's why I pray this matter be taken up after 2 weeks.
No objection? No. Yes.
Much obliged.
Much obliged, your lordship. May I please, your lordship, I beg to mention item number 27, your lordship. I'm praying for 2 weeks' time, your lordship. 27? 27.
Yeah, objection?
No objection.
Yes.
Obliged.
May I please, Lordship? Lordship, I beg to mention item 39, Lordship.
Mr. Pathak's matter?
Mr. Pathak's matter, Lordship. I'm praying after 3 weeks, Lordship.
No objection, your lordship.
Deeply obliged, Lordship.
Your Lordship, item number 37.
What's wrong at 37?
My senior is not well today.
Who's the senior?
M. H. Chaudhary.
2 weeks, yes.
Highly obliged.
Your lordship, I beg to mention item number 32. Pray for some time, your lordship.
Who's for a petitioner? Why? You appear on whose behalf?
On behalf of respondent number 123.
Who's he? GCDC. Yes, yeah, objection.
No objection.
No objection. It's a king matter.
Yes, Your Lordship.
Then 24 matter. Why should we keep it pending? He hasn't come to court today. Is there or not?
Yes, yes. For 2 weeks time, your
No,
lordship.
2 weeks. Yes. We'll have it next week.
Next week. Much obliged, your lordship.
He's standing at the door. Yes. Yes.
Please, Lordship. Lordship, I beg to mention item number 33. Pray for 2 weeks time, Lordship.
No objection.
Yes.
Obliged.
Supplementary list. Item number 1.
May please, my lord. This is a pension matter, my lord. Here, my lord, my family pension has been denied on the ground that marriage after post-retirement, my lord, is not recognizable as per the rules. My lord, here, I am the legal wife or the second wife of the deceased employee.
First wife dead.
First one, my lord, yes.
Then why denying pension?
Let me take instructions, Your
Yeah, my
Lordship.
lord, in fact, this
But that-
matter is covered.
that,
Your lordship, yes.
Amendment to
Yes, Your
Rule
Lordship.
48 is there.
My lord, yes. I've already annexed the judgment, my lord.
Yes, I heard Mr. C. Sharma, if you notice. MS Salino Country GA.
For 1, 2, and 3, Your Lordship.
On behalf of 1, 2, and 3. Pasa 4 and 5. You have been coming for a few days. You're not well. Yes, 4 and 5 days. Just after 2 weeks.
Obliged.
Affidavit, yes.
2.
Please, Your Lordship.
Yes.
These matters are connected SOP matters that are still pending before this Honorable Court.
Where's the state? Same, is the same memorandum?
Yes, Your. My Lord, in the
How
present
many
case,
prisoners are here?
49.
49.
They are working in the
Are they all
the
similarly
HS
situated?
department.
All similarly situated?
Yes.
You can't want a petition?
Yes, Your.
Positive?
Yes.
Positive?
Beg your pardon? Beg your pardon?
Are you
Yes.
positive that they're all similarly situated?
Yes.
Your Lordship, I do not have the brief today. I apologize.
Vaccinator, field worker, data entry operator, they're all same.
They're all ministerial staff, my Lord. Ministerial staff.
Where are they?
They are mostly posted in the DMHO office, West Gentia Hills and East Gentia Hills.
Okay, sir, Mr. Chalam.
I Sumer.
Yes, issue notice and whether he will accept on behalf of the respondent for notice required. Stop. It is submitted by the council that the matter is related to WBC number
43 2025.
Which one?
140.
No, that lead matters. WBC number
43, Your Lordship.
43 of 25.
25.
Yes, it's similar and connected to WBC number 483 of 2025 pending consideration.
438, Your Lordship. My apologies.
438. When this together with WBC 438 on the next date, interim orders past them shall also apply to the incident case.
Obliged.
3.
Yes, Mr. Kanta. The long
Yes, sir.
hiatus. Yes.
I took care of my health more and briefs. Already 38, 39 years in practice. Lordship, this is a matter where the respondent number 5, who was a junior engineer, appointed way back on 2nd of August 2018. And according to the rules, there is a rule that is in Annexure 8, which says that in order to be promoted to the next higher post, the person has to have 5 years continuous service. So the selection year where he was promoted was to the post of subdivisional officer, assistant engineer, was 2023, sometime in the month of August, November, October, November. And on the selection year, that is 1/1/2023, he has not completed 5 years. It was just 4 years, 4 months.
It's a feeder cadre.
To the feeder cadre. So in this case, the other the petitioners who are already in that post were made junior in the gradation list.
How many petitioners are here?
13, Your Lordship.
But Mr. Kanta was done in 23, the promotion.
The matter
Why
came.
now, huh?
The matter came to light only when the gradation list was circulated among the officers. It was circulated on 30th of July 2025. That is Annexure 9. And there it is written that those who are aggrieved, within 15 days you must file a representation. So on 30th July 2025, they filed a representation. First reminder, second reminder, till date, there was only verbal assurance that they were going to correct it. When nothing was done till date, so we have to come before this honorable, before your lordship for the dismissal.
Yes. You will take accept notice.
My lord, I'll accept notice for respondents number 1 to 4, my lord.
Yes, 5 notice. First was the
my lord,
Council, assisted by Sino Cloud, MS NG Shilan Guard Advocate. It's present accept notice on behalf of respondents number
1 to 4, lordship.
1 to
4. Notice to issue to the remaining respondent in 3 days. Yes.
Just that the petition has come a bit late, my lord, because the gradation list was circulated 1 year back.
But if anyway,
my lord.
Lordship, we have there is a interim application also. If it can just be subjected to the outcome of the writ petition, that will serve my purpose.
The interim matter also shall be taken together with the main writ petition.
What should I?
Yes. Just after 2 weeks or 3 weeks.
3 weeks, my lord.
3 weeks, okay. Much obliged and good day.
Slash affidavit.
4.
May I please, Your Lordship? Your Lordship, being aggrieved by the orders passed by the respondent number 4, that is the aim of Imam Lim. Lordship, there are actually 2 orders. The first one being order number so and so dated 11/7/2024, by which the pata covering the landed property at Laban under the name of the deceased husband of the petitioner was cancelled.
No, now you come challenging the
order.
Where's the order? Let's see.
The order is on page page 16 here.
Page
16.
Yeah.
If I may read the operative part, Your Lordship.
This is 24.
Yes.
Then yep. Yes.
Yes, by this order, that said pata was cancelled and further directions was given to the respondent number 5, that is the Washnong of Laban. That direction was to fix a date for a survey to be conducted in respect of that landed property, and for demarcation and partition of that property between respondent number 6 and the deceased husband of the petitioner.
You are the wife of the deceased.
Wife of the deceased husband, yeah.
So you see entitled to the entire property. What is the history behind it?
If I may come to the history of this case, Your Lordship, I'll have to go step by step from the lineage of the family, right from the grandfather of the deceased husband of the petitioner. So what happened, Your Lordship, this dispute arises, it emanated from the time when
See, your Mr. Sorry?
Harmotion, Lordship.
Yes, commotion.
Yes.
It's not more in the nature of a title dispute. Or you've come against this order, because this order is 11 July 24.
Yes, Lordship.
So that time, was your deceased husband still alive?
He was alive.
He didn't do anything about
No, he filed a complaint against, he filed before the respondent number 1. That is letter, page number 19.
For whom?
I'm appearing on behalf of District Council, Your Lordship, on behalf of my senior, H.L. Sangreso.
Who's here?
H.L.
Where's
Sangreso.
Mr. Changreso?
He's out of station, Your Lordship.
Yes.
Yes.
Yes. So they'll say yes, submit yes, continue.
Yes. However,
now what happened?
Now, Your Lordship,
you
after
see
the
operative part, this is 11 July 24.
Yes.
And there was no conduct of survey. That's been done.
That has not been done. However, after the
Has
death
been done or not?
No, not yet.
Not done. Not yet.
Not done.
Issue notice at this stage. Yes. We have to hear the prior respondent. So even if you read material or not, that's doubtful. Anyway, heard Mr. Karmotion, counsel for the petitioner. Issue notice. MS.
Dealing law.
Dealing law. Yes. Is present on behalf of, accept notice on behalf of respondents 1, 2, and 3. Notice to issue to the remaining response within 3 days. This after 2 weeks. Yes.
Lordship. Much obliged.
Daily list item number 1.
Please, Lordship. Your Lordship, I'm praying for time in this matter, Your Lordship. Since
Why praying for time?
Mr. Paske is not well, Your Lordship.
What objections you have to the application?
My lord, here only on the issue of law, my lord. There is no error apparent on the face of the
issue
record.
Of
law only, lordship. What entertaining review?
So
they have to
seeking on
satisfy.
what ground?
There is no ground, my lord. In fact, there was no direction, lordship.
Okay.
Because Now they have said that I have suppressed the fact, but in my writ petition, Lordship, I have enclosed all the documents regarding the succession certificate.
Just after
2 weeks.
due to the unavailability of the arguing counsel for the review petition.
2.
Obliged.
Item number 2.
Yes, ready today. Very good. Yes, what matter about?
Yes, my lord. My lord, the core of the matter is, my lord, the petitioner has been attempting to receive a family pension in lieu of the fact that her husband passed away in the month of May 2025. Now, we have approached the department seeking release of family pension because we are the wife. Kindly, my lord, if my lord would kindly have page 17 of my annexure, my lord. Page 17, annexure 2 of my petition. Now, this is the marriage certificate, my lord. Now, the facts are, my lord, the petitioner had met her husband somewhere around 2002. In 2003, the petitioner gave birth to her first daughter.
No, this is a sort of marriage between you and your deceased husband.
Yes, my lord. Okay. So, in 2006, we had our second child, and in 2007, my lord, we got married. And this certificate, annexure 2,
yes,
certifies the fact that we were married in 2007, in September of 2007. Thereafter, my lord, if my lord would kindly have page 22. My lord, this is the voter ID of the petitioner. Kindly note, my lord, name of the petitioner is given as there, and the name of her husband is recorded as McDonald Nagari. Now, this, my lord, in the second half of the page is kindly note the date of issue also, 18/7/2019. Now, my lord, in the course of our marriage, there had been some problems where the petitioner had to file a complaint with the legal services on the issues of domestic violence. Now, on that, my lord, the Meghalaya Legal Services had taken up the issue and at page 23 passed an order, my lord, annexure 5. If I may read, my lord.
Okay, what have you estranged? That means.
No, my lord, we have been married, my lord. On page 25.
Maintenance.
Yes, my lord. My lord,
if estranged, then how you? Why are you asking for maintenance?
My lord, there were issues on the fact that her husband had to travel and disappeared for 4 or 5 days because he was a driver, my lord.
That's why you have to ask for maintenance.
On top of that, my lord, on those previous occasions also, there was occasions where he had extramarital affairs again, my lord. So on that,
you were not cohabiting with him anymore.
Initially, we were not, my lord. Yeah. And then there were times where we worked out our problems. And again, in 2022, we approached the Legal Services Authority for enhancement of our maintenance. Now, kindly note, my lord, in 2022 as well, in the first paragraph, annexure 6, page 25.
1 second. Now, in the service book, whose name is there?
Lord, the service book, it only records the name of the petitioner's daughter.
Daughter?
Yes, my lord. For my lord, if my lord would go through this order, which is at page 25, annexure 6.
Okay, forget about this maintenance part. Yes, where's the name entered where? What's the name of the daughter? Magdalene Karni or?
Magdalene, my lord, yes.
Yes.
So, my lord.
She is your daughter?
Yes, my lord. Our daughter, my lord. So, my lord, basically, my lord, the facts have been laid, which is, we have been married since 2007. 2011, we put in a complaint with Malsa, which also recognizes that we are husband and wife. 2019, my voter ID, along with his voter ID, also were issued, recognizing our relationship and our marriage. 22 also, my lord, it also certifies the fact that I have been the deceased wife all this while. On these facts alone, my lord, it is established I have been the wife.
So orders for hearing today?
My lord, disposal itself, my lord.
Yes.
It can be
Yes,
disposed
anyway.
of.
Yes.
So, my lord, on these facts alone, my lord, the marriage of the petitioner with her husband is uncontested, has never been dissolved, and it only came to an end on the day that he passed away, which was in May 2025. Now, as per the affidavit of the state of the department, my lord, they also agree to the fact that they have been providing us maintenance up till April of 2025. Only when he passed, or only when my husband passed away, they stopped the payments. Now, reasons why they stopped the payments is, my lord, because the respondent number 6 had received the death certificate, claiming that she is the wife. Now, my lord, in order to claim the position of being a wife, a party must show the fact that they have a certification or issued by an authority that their marriage is solemnized and is recognized and registered. However, my lord, if my lord would have the affidavit by the respondent number 6,
So you divorced 2012.
no, my lord.
And then this affidavit says dissolved.
No, my lord. My marriage has never been dissolved, my lord. We have been married throughout this entire time. Though there have been issues,
What about this
we admit to the
affidavit
fact
filed
there
by
are
your
issues,
brother?
my lord. Pardon, my lord?
Yes. Anyway, yes.
So, my
What
lord,
does number 6 say?
respondent number 6 is the mistress, my lord. Annexure 1, my lord, at page 11, which
Of the
is
affidavit.
of respondent number 6 affidavit, my lord. Page 11, my lord, annexure 1 of the affidavit is the voter ID of the respondent number 6. Kindly note, my lord, her name is recorded, but her husband's name is not recorded, is not mentioned here. Number 1, my lord. Kindly, my lord, have page number 13 of the same affidavit, my lord.
Page
13, my lord, the same affidavit, my lord. It appears to be a bona fide certificate. However, my lord, kindly note the date, my lord. It's to be highlighted, my lord, the date.
25.
29/11/25, my lord. This is in November of 25, my lord, after the case has been filed, my lord. We filed this case in October, 30th October 2025, and this document has been received after the case has been filed, my lord, which states that this is to certify that respondent number 6, wife, son, daughter of Shri late McDonald Longantree. Now, this, my lord, is an issue. Why? Is because she has used this death certificate which she has received to obtain this document, which has been issued post the case has been filed, which only allows us to assume that she has used the death certificate to obtain the same, only because we can note, my lord, the name of the deceased has been properly demarcated as the fact that he has passed away. Again, on the next page also, my lord, kindly have annexure 3, page 14. This was issued, kindly note on top of the page, my lord, 18/2/2026, this year, February of 2026, after the case has been filed again. Now, these two documents have been filed only for the sole purpose of attempting to show that she has a relationship with the deceased. But, my lord...
So, because of objections, the family pension has been released.
My lord, she has received the death certificate misusing the name of my brother-in-law.
That's why, that's why, where's the affidavit of the state? That's number 4.
Number 4, my lord.
Here with Abraham.
The state does not object also, my lord.
Your Lordship, if I'm pleased to take my affidavit filed by respondent number 2, Your Lordship. That is page 2 at paragraph 6. That McDonald Nowcountry, who passed away on
Page 2,
Page 2,
paragraph, yes.
paragraph 6, yes. Who passed away on 9/5/2026 was reported to this office through a death report form 2 duly filled and submitted by Srimati such and such and such. The death report contained the date of the deceased was registered on the 22nd/5/2025, including the name of the parents and the name of the wife, wherein Srimati Dina Sawan was recorded as the wife of the deceased. This was on the basis of the report submitted by one Srimati Tabitha Walang.
1 second of objection, my lord. If they say they verified, what did they do to verify, my lord? The identities of the persons who have come to take the documents, as an issuing authority, they have to verify the identities of the people coming to take the certificate. They did not verify, they just took a declaration of both the respondent 5 and 6 alone. No IDs, no nothing, no passport, anything at all, my lord. If this is the case, anyone can go and claim death certificates at random, my lord. As an issuing authority, they did not follow their own rules in issuing the death certificate, my lord.
Annexure 1, page 6. Annexure 1, page 6. That is the death report, your lordship. Then Annexure 7, that is page 7. The brother of the deceased also came to the office. And he has signed a form.
Declaration, my lord.
And which was countersigned by the executive engineer, your lordship.
There's no ID to ensure or verify the identity of the person coming to take, my lord.
Let him complete the submission, your lordship, first.
My lord.
Now you're asking to correct the death certificate,
my lord. The authorities are here because, my lord, the issuing authority had to take, ought to have taken
now whatever
adequate
it is,
measures, my lord.
Final pension, you're claiming it also.
Yes, my lord. Because I'm the wife, my lord, and it is an established fact. They are attempting to dispute this, but there's nothing on record to substantiate any of their claims. Anything at all, my lord. The only reason why we have brought the respondent number 2 on record before your lordship is because they are an issuing authority. They ought to take corrective measures to correct the issue that they've made a mistake with. But first and primary most objection, primary work of theirs, my lord, is to make sure that whoever is coming to take the documents, they have to ensure that the people coming to take are the real people who are supposed to take. I've helped other clients also, my lord, to take the certificates, and this is, my lord, it's a farce, my lord. This is a farce, my
means
lord.
that your marriage is not controverted, correct?
Not at all, my lord.
That by them or by anybody.
They are
That's the only
attempting
thing
to.
then. The first wife was the first choice.
Right.
Yes. Let's hear MS Sharma. What do you have to say? What's your case?
If we see the core issue here, your lordship. So, your lordship, here there are some key grounds for this. I would pray for the dismissal about this writ petition, your lordship. Here the petitioner stated that he's a wife. He's the wife of this deceased person, your lordship. If he's the legal wife of this petitioner, your lordship, then why he had filed for this maintenance petition, your lordship? I would like to take lordship in this page.
Maintenance is fine.
Yes,
that
your
is all
lordship.
right. But then, has the marriage ever been resolved by the divorce?
Yes, your lordship.
Whether
By
divorce-
customary
whether-
customary
whether-
lordship. This is the thing, lordship. That's what I want to say. This present case require extensive evidence or in a trial, your lordship, to prove the status of the wife. Just merely because
No,
he's
the thing
having
is
but
that was
this
the marriage
death certificate.
Was it
No, my lord.
divorce?
No, my lord.
Divorce,
They
your lordship.
want that granted, my lord. They want us to do that, but we have never. There have been issues in our marriage. There's no doubt.
Customarily, it was dissolved, your
So
lordship.
after 2011, now
Yes,
your
your
marriage is
lordship.
registered in. I mean, this marriage certificate is dated 2011.
2007.
Is it a fact that after 2011, then
We were still together, my lord.
cohabit, you not
We
cohabiting
were there. We
anymore?
were there, my lord.
No, lordship.
They were staying together only for 1 year before he passed away, and that is confirmed by the department, my lord.
Further hearing, this apply.
Yes,
upon-
lordship.
My lord.
Yes, your lordship.
You have to show 1 week. Yes.
Yes, lordship.
You bring authorities. But then, if first wife uncontroverted, then
My lord, if they claim
satisfy
customs
your
and
lordship.
traditions, they have to bring something on
first
record.
name
my
is
lord.
first wife.
your
They have to bring
But
something
you're
on
not,
record,
you
my
didn't
lord.
register any marriage with him.
No, lordship.
You're told outsider. And the only thing is that, do you have any issues with him?
No,
No
lordship.
children.
No children, your lordship.
Then
No, lordship, but
Lord, and
they have not
the
come
funny
with
part is, my lord,
the
respondent
full fact,
fee
your
for-
lordship. They are
Yes.
suppressing the fact because I can satisfy your lordship if your lordship
have
give
next
you
date,
another
yes,
2 weeks
otherwise-
of time, your lordship.
first wife, first choice. Yes.
No.
Yes, your lordship.
Oh, it's some urgency, my lord. Kindly, my lord.
Next matter.
Item number 3.
Deeply,
Much obliged.
deeply grateful, my lord.
Yes.
Please, Lordship. Lordship, I have filed, Lordship. I apologize for the delay, Lordship.
For the affidavit.
Lordship.
Yes. Yes, affidavit. Respondent 4, right?
Lordship.
This has been filed. Yes.
Lordship.
Yes.
Yes, I have received, my lord, the affidavit.
Report for hearing.
My lord, yes.
Is a pension matter?
Yes, my lord.
Then we'll try to dispose of.
Lordship.
You are the state.
Yes,
Yes, sir. This is matter for hearing. Please, a complete matter for hearing after 1 week.
My lord.
Yes.
Obliged, my lord.
Master.
Oh.
Now, suppose 124 supposed to file some. Where he's supposed to file some documents.
Allow for 2 weeks time to file the affidavit to bring on court's the.
Why was MSPS Nongri?
She's out of question.
I'm for respondent number 5, Your Lordship. I'm supposed to bring instruction. I'm still waiting instruction, Your Lordship.
Your Lordship, I'm praying if the state respondent here may be directed to file an affidavit as to how much funds have been released to the district
We
council.
can't direct them. Let them file affidavit. Yes, you release funds to them.
Lordship,
For that, Your Lordship.
I'm just praying for some time, Your Lordship.
And Mr. Pala for respondent number 5. And you are sorry. Yes, Executive Vice MSP Nongri 124. Before another further 2 weeks time to bring on record affidavits at allowed by this court.
Lordship, 4 and 5 are connected.
Lists after 2 weeks. Yes.
And
Lordship,
yes.
Lordship.
May it please Your Lordship. Your Lordship, I have already filed the affidavit.
Very good. You filed agenda? Not
Yes, Your
necessary.
Lordship. No, Your Lordship, I'll file a agenda.
Yes, 2 weeks time has been out for rejoinder after this one.
7. May it please Your Lordship. Your Lordship, I filed
Let
the
the file come.
I apologize, Your Lordship.
Yes. Yes, you're there also.
Yes, Your Lordship.
Not file affidavit.
Your Lordship, I have filed, but it's in the process from judicial
Today?
section. Yes.
MSC Jala for the respondent submits an affidavit being filed in the course of the day. Yes.
We'll file
Yes,
rejoinder
for
thereafter.
2 weeks thereafter for rejoinder if any.
Yes, Your Lordship.
8. May it please Your
Yes.
May it please Your Lordship. Your Lordship, I filed an affidavit.
It's filed.
Yes, Your Lordship.
Lordship, here also I'm praying for rejoinder.
Yes. Has prayed 2 weeks time out for rejoinder. Yes, just after 2 weeks.
Obliged, Your Lordship.
9.
Please, Your Lordship. My Lord, I'm praying for 2 more weeks' time to file a rejoinder.
Why? How many times have you taken?
This is the 3rd time. The petitioner is not keeping well, my Lord. He's still undergoing treatment.
File an opportunity then.
He's still. We will
You will
try
give
our
3
best.
weeks then.
Yes, underwent stent implantation, dialysis treatment, and all. So
Further 2 weeks is prayed, but 2 weeks is prayed allowed for rejoinder and just thereafter.
9 and 10 are
similar
connected.
prayer.
Your Lordship.
What's the matter about?
It's non-payment of the contract bills, my Lord.
But there was some other case where the amount was released. It's not this one.
Your Lordship, even here, whenever funds are available,
And that is the plea.
bills have been released.
No, not
Your
JJM.
Lordship.
Repairing works in PWD Health Department.
Yes.
11.
Obliged, Your Lordship.
Yes. Yes.
We'll take instructions, Lordship, on the names
Yes,
that provided.
yeah, Mr. Diwani. Yes, submits an affidavit file today itself. When are you filing it?
Yes, Your Lordship. During the
To
course of
bring on record the suggesting the names of the potential arbitrators, list of arbitrators. Yes, MS Amrichang, please fill up to take instructions on the said name. List after 2 weeks. 1 week, okay. Yes.
Well,
Right, Your Lordships.
Yes, to this one. What has happened?
Maybe His Lordships, this matter may be pass over for the lens of what Lordship.
Oh?
Lordship, I'm without instructions, my Lord. My Lord, I'm without instructions as of.
Where's Mr. Advocate? He's here.
Yes, my Lord. He's next before the division bench, Lordship.
Yes, tell him to come now. After him comes.
13. If you may please, Your Lordship, steps have been taken to file on the respondents, and as per the status report, the same has been delivered.
Who's appearing for the respondent?
So I pray, Your Lordship, you may file an affidavit to bring on record the status. This is with regards to the salary of the petition not being
No,
released.
I mean, now you see instructions that she's been served.
Your Lordship,
But the office note says that it's not.
the AD card has not been returned, but the status report that we've received, that's already been delivered.
Yes, MSC Kiswanas prays that she will have obtained serial service on the respondent. She also prays government to file an affidavit getting service.
That's right.
Yes, before the next date. Just after
1 week's time, Your
1
Lordship.
week.
Highly obliged, Your Lordship.
14.
Yes.
14 and 20, Your Lordship, it pertains to those franchise
14
which
and?
14 and 20, Your Lordship. In 14, letter of award has been cancelled, Your Lordship. It pertains to MECL, Your Lordship.
This is instructions as well.
The letter of intent has been cancelled, and that cancellation is under challenge in item 20, Your Lordships.
So you will close this one.
Lordship, if in fact we appreciate
No point of replication. Yes.
allow us to take some instructions in item.
Last time you already said you wanted
14,
instructions.
Because the main issue there is with regard to the trading license, Lordship.
Where?
In item 14.
In this 67.
Yes. Whether trading license is required or not for essential services. In fact, that is the issue there.
No, so you wanted to be educated.
Lordship, if we can keep for some time, Lordship, because 20.
Yes, Ms. M.L. Nongpure submits that though subsequent developments are there wherein the letter of intent,
yes,
the cancellation letter of intent has been challenged. However, prays that the matter be kept pending as other issues are present, which need adjudication by this court.
Lordships.
Okay, yes. This together with the next date. What about the other matter?
In item 20, it's fixed for affidavit, Lordships. Till date, they have not filed the affidavits.
Yes.
We'll be filing lots in the course of the day.
Item 20. I know. Your respondent number?
Number
3 and 4.
3 and 4. What about 1? 1 and 2 on file. Your file. Yes, Mr. A.S. Pandey for 3 and 4 submits that the affidavit on behalf of the response will be filed in the course of the day. MSZ Independently for 1 and 2. You're appealing for whom?
For respondent number 8, Lordship, in item 14.
And the other matter is SC 1-2 submits that no affidavit forthcoming from the respondents. Just after
2 weeks, we'll liberty to file rejoinder.
Or rejoinder if any. So, to other matters, the list number.
Obliged.
15. 15.
My lord.
Yes.
As I'm appearing for respondent number 2, we're taking over as new counsel on behalf of respondent number 2 in this matter.
Who's one number 2?
Respondent number
Gem,
government.
GM.
Yes, Your Lordship. Yes.
Have you filed affidavits?
Lordship,
My lord, my instructions are that my client has not received a copy of the paper book. I understand from a perusal of the records that in the previous orders that a certain local council had received
Who local
notice,
council
but
previously? You were there.
No, no, you are respondent number 5.
Mr. G. Das, I have a new local counsel, Ms. Alfari Nongri, who's in court present today.
1 second.
Counsel. So, if my lords may be pleased to just have the
Have you filed your
petitioner's
wakalats? Have you filed your powers of
we'll be doing that over the
Yes,
course
you
of
are?
the we have brought in
Yes.
Miss Vinci Suzy.
Yes, MS B. Suzy.
BINS Vinci.
Yes. Yes. Has entered appearance on behalf of respondent number 2 today.
Oh, respondent number 5 has been filed.
Yes. Wait 1 second. For 2, and praise for how many? MS also has appeared today on behalf of number 2 and submits that she is the new substitute counsel in place of the earlier local counsels who are appearing in the matter. Submission is noted. She further submits that you don't have copies of the writ petition.
No, no, my lord.
She has not
We've
said
not
that
received.
they have not received copy of the petition. Stop. Petitioner supply copies to the local counsel who's present in court today for respondent number 2. And what do you want?
We'll file an affidavit for respondent number 5.
In the course of the day.
We've already filed the one.
Yes, Mr. Majao for 5 submits that the affidavit says what about for 1, 3 and 4?
We've served them a copy, Lordship, will be filed in the course of the day.
Yes, for respondents 1, 3 and 4, and Ms. Emily Chang submits that affidavit filed in the course of the day. How much time you require for your affidavit?
3 weeks, my lord.
3 weeks. Okay, 3 weeks we have to get a copy. Yes, this up to 3 weeks for affidavits. Affidavit by the respondent number 2 and further orders. Yes.
My lords, if you may also note that the copy be served to Miss Alfari Nongri because I don't want to sit.
Yeah, you supply to local council.
Yes, sure.
16.
Yes.
Please, Lordship.
We have filed the affidavit, Lordship.
I'm praying
Yes,
for time.
MLB, sir, what do you want?
I'm praying for time to file a
No
rejoinder.
rejoinder.
We'll file a rejoinder.
Yes. Wait 2 weeks time allowed for rejoinder affidavit.
17.
May please, your lordship.
Yes.
Yes, after lordship intervention, we have received compensation of 1,50,000, which is not just and reasonable.
Who the print for MECL? MECL.
My lord, in this case, they have come for compensation, and we on one of the occasion, my lord, I have placed the assessment. So state was supposed to approve it, so they have approved it. It appears.
Your lordship, the state has no rule, lordship. The payment is to be made by the authorities, MCL, your lordship.
My lord, this is based on the ex gratia scheme of the state.
Yes.
Yes, it is state, my lord.
What instruction do you have?
This is the expression statement.
What was your submission? They have funds. The boy died.
No, my lord.
No, still alive.
Oh, sorry.
Still undergoing treatment. Even blood transfusion also monthly, like 1 month. Lordship, I'm relying on these two judgments. Because the compensation must be just and reasonable.
Of course, but then they've done an inquiry. The inquiry shows that it's non-fatal.
This Lordship last page recommendation, point number 2, the wooden plank fence should be either be removed completely or should not be attached to the sustained fencing. So it was completely like on the motion of
You file additional affidavit. So what treatment have you undertaken so far after you file the petition?
like twice amputation, and then there is like undergoing treatment.
You file additional affidavit, then consider. State also consider. You will you file affidavit?
No, my lord. I have only placed the inquiry report, my lord.
Yes, you file affidavit. Yes, you're Mr.
Enupadhyay.
Enupadhyay. Petitioner submit that though a compensation amount of rupees 1.5 lakh has been received by the petitioner, these said amount will not suffice for treatment of his son, right?
That's it.
Petitioner's son.
That's it.
Yes, who's undergoing grievous, who's undergoing specialized treatment in here or Guwahati?
No, in Paras, Patna.
Treatment in Patna. Stop. Respondents to file affidavits within 2 weeks. Yes. But petitioner also permitted to file additional affidavit and record the treatment that's being
undergoing
to the petitioner's son. Yes.
18.
Oh, please.
Wait, please, Your Lordship. Your Lordship, I'm praying for some time to file an affidavit.
Yes.
Lordship.
For a 2 weeks time. Garam pani do.
Hello.
Obliged, Your Lordship.
19.
Your Honor, which served upon the Kanpur sub branch, which...
You're appearing for whom?
Your Lordship, I'm appearing on behalf of Miss N.G. Sheila for respondent number 1.
It's not behalf of respondent 1.
Yes, the bank.
You've been served.
Yes, my lord.
Were they present before? No. Yes, 14/7. You're not filing affidavit.
Yes, Your Lordship, we have just filed the Vakalatnama.
What is your name?
P. Roy.
P. Roy. Where's P. Roy on behalf of respondent 1? Please spell out. Your account is operating it now, right?
Your Honor,
Yes,
there's been a lien hold. Your Honor, we have received the delivery report from the post office.
Regarding?
Since the delivery on respondent number 2, the Kanpur cyber branch.
Yes,
They have received it.
Cyber Crime Cell DCP West Zone.
Yes, they have received it. That is the date of delivery is the 1st of July 2026. But I believe it has come back unserved. So, my lords, it may be noted that there's a valid delivery. It has been effected.
You don't know that what's the status of it. You take fresh steps. Eliminate, yes. Though MS Shyam, I thought I'm to go further. Please. To extend file affidavit, stop and decline. Though MS Shyam submits that service has since been effected on respondent number 2 and has produced a communication dated 27/2026 issued by the Department of Post Offices. Stop. However, the said notice has returned unserved. Petition to take fresh steps within 3 days. Just after 3 weeks. 2 weeks. Right.
21.
My lord, Lord, I'm extremely sorry, my lord. As in terms of your lordship's direction dated 15/7/26, we were supposed to make a payment of 1 crore 30 lakhs, lordship. However, lordship, we have only been able to pay an amount of rupees 75 lakhs, lordship. And lordship, the other 50 lakhs also was deposited, lordship. The only difficulty is, lordship, that my escrow account. Lordship, there's a limited transaction, lordship. Now I am being able to, and I am paying for my personal account, lordship. And lordship will try to make the payment within today, lordship. The remaining 55 lakhs, lordship. Lordship, if lordship have the chart, lordship.
See, this order is dated 15/7. The pressure immediately in a period of 3 days from not later than 18/7, deposit amount of 50 lakhs only for respondent corporation. Did you comply with that?
Lordship, we have paid that 50 lakhs.
The 3 days, 50 lakhs.
Lordship, we have paid that, lordship.
On such reconnection, the balance amount of first installment be paid not later than 10/8/2026, and the remaining amounts on the 10th of succeeding month.
Lordship.
Now you're supposed to pay by 10th of August 1.3 crores.
Lordship.
Then 10th September 1.8 crores. Yes.
Lordship.
What happened?
Lordship, we have paid an amount of rupees 75 lakhs, lordship.
In 10th August.
Lordship, before that, lordship, 10 before 10th, and lordship 55 is remaining, lordship, and we are making our best effort, lordship, to pay the remaining 55 by today, lordship.
By today?
Today, lordship.
We'll have it after tomorrow, Mr. Pandey.
Lordship. The difficulty is, lordship, my escrow account, lordship, there's a limited transaction, lordship, which I am facing some difficulty, and
you're operating on escrow account,
lordship.
You're operating your own escrow account.
Lordship,
now to operate it.
There's some problem with the technical issues with the account, lordship. That's my instruction,
How is
lordship.
that?
Lordship. That's why, lordship, I'm making the payment.
I don't think there is a valid excuse that you can, there's some problem with the escrow account.
Lordship. And lordship, that's the reason, lordship, why I'm making payment through my personal account, lordship. And the limitation is that, lordship, I can make a payment of rupees 20 lakhs per day, lordship. So that's the difficulty, lordship. Otherwise, lordship, I'm making.
That day after tomorrow, Mr. Pandey. Yes.
Just my objection may be recorded.
No, we'll record your objection day after tomorrow. We'll dispose it off also. Yes.
Lordship.
All right.
This matter, they have to enable Mr. Pandey to obtain instructions. Yes.
Lordship.
Whether any whether they will do the course of the day or not, let's see, by day after tomorrow. Otherwise,
lordship.
22.
Hello.
Wait, please, your lordship. Lordship, I'm entering appearance on behalf of Mr. M. Sharma for respondent number 5, your lordship.
Your lordship, have also taken steps for respondent 3 and 4 on the last day, your lordship, and the same was delivered.
what's the matter about?
Your lordship, yes, your lordship. Your lordship, if I may be allowed to file a affidavit of service for respondent 3 and 4 next year.
MSBF Karavana under appearance today on behalf of number 5. With regard to respondent 3 and 4, MSGC Marco prays that we be allowed to obtain status and file affidavit if necessary.
Your lordship will be filing a Bakla Naman in the course of the day.
Affidavits by the respondents 1 and 2. 1 and 2 will file anything? No.
No, your lordship.
By respondent number 5 within 2 weeks. Yes.
Highly obliged.
23.
As per the last order, lordship, I'm supposed to take instructions. This matter pertains to the election of headman of Saidbakan village. Now the nominations have been kept in abeyance because there's a complaint from the village against the voter list, lordship. If I can submit, lordship, I'm willing to participate in the proceedings which is pending before the CM of Khairam's CMship, lordship. I'll implicate myself in the proceedings and also file my written all my objections before the CM, lordship.
I have two submissions to make, Lord. There are two new developments. One is that the acting or the CM of Malayam or the CM of Khairam's CMship, Lord, has passed an order directing the petitioner to prepare for the election. I have the letter here. And the second development is that, my lord, I have been removed from the acting headman of the Siamkon village. So, in view of these new developments, my lord, this petition is.
Who's acting?
Acting is respondent number 5, my lord.
The respondent number 5 is responsible for preparing the draft, lordship, which is. We say that he should
I
have
supply
not
this,
prepared the draft.
letter.
You are whom?
I'm the Sardar, Your Lordship, of Rajabong.
Rajabong.
Yes. Because as per customary practice,
You're acting Sardar. What's your name?
acting Sardar.
You didn't put
Bigat
your name
San,
here.
Lordship. Bigat San Chabong.
Should have put your name here.
Lordship, there's an affidavit.
Yes. It's been removed.
No, that is the second issue. The first part, my lord, is this letter.
But then you already prepared the voters list.
Yes, they.
So then what remains?
If my friend can supply the
Objections by
copies.
whom?
Pardon, my lord. The voters list has been prepared by us.
No, yes, you prepared.
Yes.
Then what objections is there to the voters list? By whom?
The objection here, my lord, is this writ is no longer maintainable. In view that what they want here is that for them to conduct the election, to hold the process for conducting the election. Now the CA, my lord, has passed this order allowing them to go ahead with the election process. Now this is a letter which I want to place before your lordship.
Can be disposed of. This is quite clear, Your Lordship. Direction is issued to the
Now this writ is
Sardar,
no
Your
longer
Lordship.
maintainable, my lord.
Yes, it's given to you.
Lordships. I'm not aware of this, Lordship. The
Then,
matter can be disposed.
Mr. Emerald Leonard Council just submits that due to the present development, especially the order dated 29/07/2026 issued by the respondent number 4, Yom Khairam, nothing survives consideration the matter.
Lordships.
Copy to Benshu.
Calling submissions of the Leonard Councils, the matter stands closed. Copy communication at 29/7/26 in the vernacular is taken on board with part of the report.
Lordships. Obliged.
24.
Lordship, we are waiting instructions.
Lordship,
What's the matter about?
this is matter, Your Lordship. What happened actually? Initially, I was appointed as a dark runner.
Asking regularization?
No, regularization. No, now they have converted me into the contractual basis. I was never appointed as a contractual basis.
Just after 2 weeks affidavit.
Yes, Lordship. This is miscase. I may be just allowed to withdraw. If there's some defect in that my miscase petition, I'll be withdraw with my liberty to file. I have filed actually the
connected to this one. Mr. P. Samar plays without to withdraw in this case with liberty to file a fresh
Lordship.
advice.
Lordship.
Praise allowed.
Lordship. Much praise, Lordship.
This case stands disposed of as withdrawn.
I will do respond.
25.
The 25 instructions affidavit. I'm praying for some more time.
What happened to the review medical board?
It has been conducted. And
You didn't conduct. What's the report?
But we were awaiting instructions.
He said the review medical was conducted on 19
found unfit.
8/2025.
Yes,
What happened?
He isn't found unfit, man.
Unfit. Where's the report?
The report. I'm
Did you
awaiting.
give it to the petitioner?
It has not come. We'll file the affidavit. Man. We'll file with the affidavit.
Is submitted by Leonard Senior Counsel that in the review medical board, why you to take 1 year then to communicate it has been found unfit. He prays he may be allowed to place the same with affidavit. This court notes that it's not understood as to how if the review medical board was conducted on 19/2025, the same was not communicated to the petitioner. Just after 2 weeks for affidavit. Yes.
Obliged. Sorry.
26.
Well, at 26, I have instruction can be disposed of, my lord. Because his main grievance is, my lord, that his next medical review is due on 3rd of September. I'll just place that order. You got 6 months. Who's that 6 months? Where's the 6 months?
9 September. No, not 9.
वो 6 months कहाँ बोला था? 6 months of travel मत करो मतलब page number कितना था? यहाँ गया page 48. Page 48. 48. Page 48.
2026. So it will be 12/9/2026. 6 months later. No
Page
date is
48.
given.
Page 48. Page 48. This one.
Yeah.
Yes, P24 is 24 weeks.
His next medical review is due on 12th of September, my lord. So till then we will retain him where he is, my lord, and depending on the outcome of the medical, my lord.
Yes, today Dr. M. Muzika, Leonard Senior Counsel, has submitted that as the next review, medical review of the writ petitioner is due on 12th September 2026. His transfer will be kept in abeyance till after the reports are received on the next the reports are received on the medical report after examination on 12th September 2020.
And thereafter appropriate orders will be passed depending on the medical reviews.
Appropriate orders will be passed depending on his health condition. On the submission, so you will raise that the matter will be closed at this stage.
The requirement this is not come under repeatable yet.
You cannot file it under this thing, that's why.
As his undertaking has been given by the
Not even applicable yet. They're not
Senior
claiming
Counsel,
They are filed everything
which
under
is also
PWD.
evidenced by communication dated
mention
10 August 2026. The petition is closed at this stage.
Much.
Second
It's
call,
closed off, yes.
item 12.
Satnam Global.
May please lordship. Lordship, I pray some time to file my affidavit, lordship.
Where's the Advocate General?
My lord, he is busy, my lord.
He's on legs in the garden.
No, my lord. But I've received instructions to file the affidavit, lordship.
No, where's he? You call him? You call him now. Call him. What instructions have you received?
Lord, the matter is still pending with Ministry of Power. Yesterday only I spoke to. My difficulty and the order, my lord, if your lordship will say there is no time bound.
Very well. If that is what the AG is taking advantage of, then very well. That is the most unfair of the AG.
No,
if he has difficulty, lordship, we also have difficulty, lordship. May I just hand over this, lordship? And this is not a self-serving document. Lordship will also have to see this.
Give me fine.
Sorry. Because now see where we have landed, lordships. Thanks to the settlement, we have now being faced with NCLT proceedings everywhere. We have dues everywhere, and our company is at the verge of liquidation. And if we had known, which I had.
With the last letter which I gave you. Satnam letter.
No, that is there.
This is a with vintage, this letter.
This is. I also noted that this is. In fact, when we travelled yesterday, this was handed over to us. We only said, please give us the status of the company's health, so that we apprise the court.
These are your accountants.
Yes, but this is
1 crore 49.
These are all proceedings against me, which I would have paid back had I got this money, thanks to the settlement, which they had told me that we are entering into a settlement. Now see my status, lordships.
What are we to do, Mr. Goswami?
Lordships, as I had told even earlier, this will only happen if lordships can order of personal
We
appearance.
will file.
Otherwise, nothing will happen, Lordship.
We'll file reply, my lord. Kindly.
Lordships, I am not finished. Lordship, put me a question. This is the fourth time we have come and going. The court has been extremely accommodative. We have also been accommodative.
Yes.
4 times. It's been 7 months since the agreement has been filed. On the last occasion, the AG passes through a letter across the bar saying that now this money will come and then we will pay. This was never told to us then. If it was told to us then, we would have never got into the settlement. We were given to understand there is a cabinet decision. Please go ahead, do the settlement. We are going to pay you. And today you are bringing in one obstacle of the other. It was our duty.
How do you resolve this? Because they are up.
Yes, my lord.
They are up against the wall. You are waiting for money from REC.
Yes,
yes, REC, my lord. We are waiting for REC, my lord.
Lordship may pass personal appearance. Otherwise, nothing is going to happen. Lordship
may pass the order directing the contemnors to take up the matter with REC on Ministry of Power. In fact, now it is with Ministry of Power.
Lordship will not expand the scope.
Within 2 weeks.
Is the secretary power party here?
No, my lord. Secretary power is not a party, my lord. Only thing is that the contemnor, the MEC.
In the earlier proceedings.
No, my lord. No, the MECL may take up.
Secretary of the Government of India power.
No, it is with Joint Secretary Power, Ministry of Power. Now they are.
He was not there as a party.
It was not. They were not party. But it was a Saubhagya scheme, which was a scheme of the Government of India only. Fund came from Government of India. Everything we paid from Government of India. Even the balance amount which we paid.
You mean to say that other service providers also facing the same problem in other parts of India?
So they all got money through this process.
No, are there any other?
No, my lord. What has happened in this case?
Or are they being singled out?
No, this is a peculiar case where there were certain allegations leveled against the company for not performing the job, etc. Inquiry was conducted. After conducting the inquiry, it was found that they have done it. There was certain multiple level of inquiry.
So forget that's water under the bridge.
So
now what is the real impediment?
No, real impediment is
how could you enter on settlement knowing fully well the money is not in your hand?
No, that is why, my lord, in the order there is no timeline. In the order, if your lordship will see, because contempt, they are alleging that I have violated the order. If there is a timeline in the order saying that I have to pay this amount by so and so, and that is the reason why that there was no timeline. Reason was that we have to get the money. We have got 2 options, my lord. I will place before your lordship the correct fact. Either the Ministry of Power says that we will not give you money, then we will, because cabinet has already taken.
How much do you know? How much to get?
About
more than 40 crores.
33 of 30
40.
About 40 crore rupees or 33 crore rupees, my lord. That figure I don't have right now readily available, my lord. But, my lord, we are waiting for even yes or no from Ministry of Power.
This was the same submission last time also made.
I know.
This submission will be made again next time.
Swami is angry with me.
No, I'm not angry, lordships. I'm not angry. If this would have been told to my client when the agreement was signed, I would have never entered it. I would have
agreement is very clear, my lord. Agreement is clear. No timeline. So therefore, if they say that there is a willful disobedience of the order, my lord, it is not correct. The lordship may have it after 2 weeks. Probably we'll have some solution.
No, that is even last 2 weeks before also the same. Probably we'll have some solution. Now, lordships, my request is, lordships, I think so. It is more than prima facie evident that there has been a willful violation.
Even if we put him in a civil imprisonment, he would be able to.
No, that would come in. That would, lordships, I can assure lordships, I can assure lordships from my limited experience, my lordships have far bigger experience than me. Call for personal appearance. The next day, the money will be on the table.
My lord, we will file the reply.
Because I have recently done a contempt. They were not giving appointment orders. The chief secretary was called overnight in Delhi. He should.
That is different.
No, that's the same thing, lordship.
Money and this MPDCL.
Lordship, bureaucracy is bureaucracy. We know, lordship.
No, there is no bureaucracy because if we have paid the amount.
No, lordships, I think so. We have spent enough time on enough of judicial time, lordships. Lordships may call for a personal appearance, otherwise nothing is going to happen after 2. And lordship will also see that we are traveling, we are going back, we are traveling. Of course, Sri Lanka is a good place to come, no doubt about it.
Can join.
And see my company's health, lordships. Please see my company's health, that's why I placed this.
My lordship, at the end of the day, there was no definite time period.
So he is taking advantage of something.
And therefore there has to be willful. There has to be willful. There has to be willful, my lord, and therefore I will place the reply. I will file the reply, my lord. Kindly give me time so that in the meantime it is settled.
You file in 1 week, otherwise you'll call personal appearances.
1 week.
Today also, today that is Advocate General appearing for the respondents has put up the same excuse that the to satisfy the amount arrived at a settlement, the funds have to be received from the Ministry of Power, more specifically from the REC, that is the regional. What's it called? This is the REC is Rural Electrification.
Rural.
Yes, from more particularly from the REC. Stop. Next, it's not understood under what circumstances the settlements arrived at if the fund position was not clear to the respondents. In review of the matter, they are directed to put an affidavit within 1 week, feeling which personal appearance of the CEO
alleged contemners,
of the alleged contemners shall be called.
May I just request some? I just seek a little under. Lordship, they will file an affidavit indicating by what time they'll pay. Otherwise,
let me file the affidavit.
Let them file an affidavit by what time they will.
Even the third personal appearance at them will be enough. Yes.
Yes.
Failing with Lordship, there will be a personal appearance.
Yes. Yes.
Very well.
Hearing?
Different. With any day? 1 week. 1 week if I affidavit.
1 week.
Then we post it after, then immediately thereafter.
10 days. 10
It's a little bit.
Yes.
Very well.
I'm here.
Hearing? 28?
Yes, Mr. Bora.
Yes, my lord. May I please, my lord? But the other counsel is not here.
Who's appearing for the state? Who's appearing for the state?
Thaba,
Which Thaba?
son of Mr. Rabi Gurung. I forgot his name, exact name. I saw him around.
Oh, are you arrested? Grievous hurt.
Yes, yes, my lord.
He was here today. Where is he?
I saw him around, maybe engaged in some other court.
Here?
Here only. Can wait for some time. Maybe he is busy in some other court.
We will have it after 1 week. He'll be available.
He's available in the court.
Are you available after 1 week? Yes,
I'll
Mr. P. Bora's present behalf, the P. Bora's present behalf of the petitioner on the PS for respondents. Some interest of justice. This is matter tomorrow? Okay.
Next matter also same.
Tomorrow is
29.
Yes. We'll dispose them of.
30?
Oh, he's come. Mr. Thaba, I read you the matter. Yes.
Lordship, this item number 30, I'm seeking some time to argue, my lord. This item number 30, seeking for adjournment, Lordship.
What item 30 is this?
This is Nokma matter. I've informed to the private respondent also. This is GHDC also is here.
Yes, 28, 29 now. Yes, okay, 30. Yes, should mention the middle. Anyway, yes.
Much less,
yes. You can finish in 15 minutes.
Yes, my lord. I will be as brief as possible. My lord, I and my friend, the petitioner of the other case, 372, we too are from 3rd Battalion. We were sent for training in 2nd Battalion at Tura.
Yes.
Now there, an incident happened where a Garu boy was killed, and there was a case registered against 8 recruits of the 2nd Battalion who were in the 2nd Battalion. We too were also amongst them. 6 were from other
other
battalions. 2 from 2nd Battalions, 4 from 6th Battalion, and 1 or 2 from 4th Battalion. Then after I got bail from the court, as soon as I got bail on the next date, I was put on suspension by the commandant and from 2nd Battalion, and we were asked to go back to our parent battalion. We came back to our parent battalion. We stayed there as suspended recruits. And during suspension, I was given suspension allowance up to, it's on page 4 and 5 of my petition, my lord, up to under paragraph 6, from up to February 2008.
When this incident happened?
Incident happened 2007.
7?
Yes.
What happened after that?
The matter is under trial now. Now what happened?
2007, now we are in 26.
Yes, my lord. No, we were under suspension. I was getting the allowances up to February. Thereafter, without any notice, without anything, they stopped paying me the subsistence allowances. Then in 2014, by the impugned order 28/8/2014, at the impugned order 28/8/2014, we were our services were terminated. Mine also, my friends also. Since 2008 to 2014, no allowance of any sort was given to me. We stayed in the battalion, no any activity, only eating and sleeping, and morning roll call and evening roll call. We used to go after, most of the time, since we are not getting money after 2008, after morning roll call, we used to go out and find some casual jobs for livelihood. So since then we are going to the trial court in Tura, because we had been told by the commandant himself that once you get out of the case, you are acquitted from the case, you will get back your job. Now, out of the 8 accused, 1 expired. 5 of them, they have got their job immediately after. Their jobs have not been terminated. They are also serving in the police. One has reached up to the rank of Havaldar now. Now my question is here, Police Act is same, Meghalaya Police Act, rules are same. Now, when 5 of the recruits who are also involved in the murder case, who are still serving, whose service have not been terminated, why our service has been terminated? Under the same police rules, same police
Now you
act.
come to the order. What's wrong with the order? You have to challenge this one. You need 8,014.
Yes, my lord, there was, this order is manufactured in a way. It is not correct, because it is here, apart from the this murder case, 2 allegations have been added.
Forget about that, Mr. Bora. Now, were you given opportunity to represent yourself in the inquiry?
No inquiry was held, my lord. Regarding the...
These are findings. Even was drawn up against RC and things and on behalf of the involvement alleged assaulting the GSU member, White Torapia's case. Then during inquiry, prosecution was examined by inquiry, also statement was corroborated. Alleged that he was attacked by Garo boys.
Yes, that was the incident.
Subsequently, he had reported a matter to his friends or assistants. The connection has been pointed that if you attacked, you should have informed the officers. However, you didn't inform. Then?
Actually, we were not involved in that incident at all. That is the allegation only.
See,
and against that, the trial is going on.
See, we're not going to sit and appeal over the findings.
But this is only allegation. We have not been convicted.
We're not sitting and appeal, Mr. Bora. The only thing is whether in the course of the proceedings, the procedure is correct or not. If the procedure is correct and you've given adequate opportunity to women to give your statement, that's enough. That's all. Have you filed appeal against this?
No,
per the Police Act.
because
Why?
the time limitation has lapsed. Section
Yes,
17.
What have to say?
Your Lordship, there has been no violation in this matter of
No, no, they have not filed appeal.
Yes.
How many days for appeal? 60 days. Under 77,
Yes, 60 days.
Rule 78. What's it? Under rule?
Rule 17, I think.
Before the Police Act.
There was alternative remedy, Lordship. They could have went on.
That is what under section 17 of the police. Yes, under Rule 17 of the Meghalaya Services Discipline and Appeal Rules.
Yes, under
Rule 17 of Meghalaya Services Discipline and Appeal Rules.
That will come to the Police Act. Yes, Police Manual. It'll be 66, I think.
60 days, and the limitation had 2014.
No, 2014 till now. That's the biggest question. What are we doing?
No, actually, we were advised by the commandant to go.
No, 14 till now. 14, now in 12 years ago, you were dismissed from service, right?
Yes, my lord.
Then?
No, we are advised that you,
then you
carry on with the trial. After you get acquittal, you will get your job.
Since 2014, then there's nothing to show.
We were totally.
You came out.
We didn't know, my lord. We were advised by the commandant himself, who passed this order, that you get acquittal from the court, you will get it back your job. So we believed him blindly, and we have been appearing in the court, going through it. And then
chances in the court.
In the court only met the advocate, and advocate said that you can still go for reinstatement.
See, departmental proceeding is a different matter from your criminal trial, correct? Departmental proceeding, the standard of proof is much lower. Now, departmental proceeding, you have to show that it's vitiated for certain reasons, correct? Maybe, but then in your case, you've been heard and you've come after 12 years. Doesn't ground delay?
Yes.
Delays because it has been so much delayed that we cannot go by condonation
still
also.
Pending, Lordship. So what is the point of coming? Because since their ground is that.
So your grounds that, yes. Take down, yes. These both are similar.
Both are similar. In the other case, I did not get any subsistence allowance since the beginning.
Subsistence allowances, that's another thing. It's not in
as Tingshine,
it will already been removed since 14. Yes, sir.
Then 3 incidents have been said in the order. One is the
climbing the wall of the women constable.
That is also false. No inquiry was held. No departmental inquiry was held. Only based on the same case, 5 are serving in the police, and we 2 have been thrown out.
They did not climb the
that is my main grievance.
Wall of the room. They have not completed the
no, that is a false accusation. There was no inquiry about that.
These 2 petitions being similar and identical in nature are being disposed of by the common order. Stop. The petitioners who were trainee recruits with 3rd Battalion, both of them, no?
Both of them from 3rd Battalion.
3rd Battalion of the MLP.
Others from other battalion are still serving.
From MLP are before this court impugning the claiming for reinstatement. You haven't challenged you not even challenged the impugn order. Are before this court. Not impugning, before praying for reinstatement into service and for payment of all back wages, allowances. Stop. The brief fact it appears is that the 2 petitioners, the petitioners in both petitions, were arrested in connection with the sale property, with were arrested in connection with Tura PS case number 58-5 of 2027 under sections 307, 326, 34 IPC and 127/5/2007, whereafter both were placed in suspension. Stop. From the materials available, it is seen that departmental proceedings were then drawn up, and by separate orders of the same date, by separate orders dated 28/8/2014, were discharged or were removed from service with immediate effect. Stop. Next paragraph. Mr. P.Q. Bora submits that the two writ petitioners, even during the course of the suspension, were paid substance allowance only up to
February 2008.
And thereafter, though still in the battalion,
till the date of termination, nothing
though
was
still in the battalion, while the proceedings were on till the date of removal of service, were not paid
anymore
subsistence allowance. He further submits that certain other recruits were also involved in the said incident, but however they have since been reinstated
Yes,
service.
they are still in service.
They've been
in the counter affidavit, I have given a list of those names also.
So, he therefore prays that the respondents be directed to pay the outstanding substance allowance.
Lordship,
which has
no,
not paid.
no, there is
That's
a vehement objection.
That's a submission. I'll record his submission that he prays that we should that they be paid the pending or the outstanding substance allowance and they be reinstated into service.
Yes.
Now, Mr. J. Thaba, on behalf of the respondents, what's your submission?
My submission, Your Lordship, is that in subsistence allowance, they were supposed to comply with the rules. That is that they were, as per the order passed, they were supposed to remain in the headquarters and not to leave from the headquarters. And Lordship, that for that
we never left the headquarters. We have been in the battalion throughout.
Lordship, their records are there with us. He is absent. He has not signed in the register.
The records, the morning roll calls and the evening roll call records are not here. We are present every day.
No, we have the records.
Manufactured, like the story.
His friend,
climbing story, they have been manufactured. There is a grudge of the commandant against two of us, it seems.
I may be allowed to.
He went and stabbed one person.
He has only partly been in the headquarters, Your Lordship, for which his subsistence allowance was paid to him accordingly for Tingshing Nang Klau, the second petitioner. Whereas for Amit Marbidiang, he remained absent throughout.
Throughout, we have been in the battalion itself. We have never gone out of the battalion till 28/8/2014.
The entire rules was explained to him. Wide communication.
False allegation, my lord.
Yes, now you take down. Mr. J. Thaba, Learned Counsel for the respondent state, has submitted that the petitioners were given adequate opportunity and department proceedings were drawn up, whereafter they were removed from service. With regard to the payment of substance allowance, as far as the petitioner in WPT 371 is concerned, they submitted that all dues entitled during the suspension period with effect from January 2009 to August 2009 and October 2009 to December 2009 and January 2010 to September 2010 had already been drawn by the separate petitioner, and the other periods remain and for the other periods, as a petitioner was not was found to be absent from battalion headquarters with effect from 30/11/2010 to 28/08/2010, in spite of instructions to remain in the battalion. The same, the petitioner entitled to the said payment. So, with respect to the
Regarding the absence also, there was no inquiry made by the commandant, by the battalion.
The order.
That's his submission.
Yes, yes.
Yes, with regard to the petitioner in C72. What about 372? Here, for Amit Marvanyang also is seeing same thing, same affidavit you file.
Yes,
Then?
yes.
What about him?
Both of them, they have more or less the same case. The only part which differs, Your Lordship, is as to subsistence. Tingsheng Nongklau, he has been attending in the headquarters and has partly complied with the
affidavit filed in Amit Marvanyang.
Yes.
See in para 12, what you've written. You didn't bother to correct the petition, the affidavit also. See page 5, para 12. The petitioner Tingsheng Nongklau.
Lordship, that error, of course, we noticed it, Your Lordship. It was made by the junior, Your Lordship.
By
the junior.
Don't blame anyone.
Okay.
You're the one who filed affidavit.
Yes. We had to make some corrections in that. That was an error. We have
What's
observed
the
it.
case with regard to this Amit Marvanyang? You see, if same affidavit filed, this is the kind of affidavit filed by the state.
Lordship, the case is more or less.
Be removed.
The case is more or less the same, Your Lordship.
With regard to the petitioner, we'll just condone it. Otherwise, it is submitted that the situation was also the same.
They're not regular constables as well.
He therefore submits that no case having made out, the petition deserved to be dismissed. Next paragraph. This court on hearing the council of parties firstly notes that the impugned or the order of removal has not been subject to challenge by the petitioners. A perusal of the same, however, would reflect that adequate opportunity had been afforded to the writ petitioners who, after due process, after the order of removal was passed, the writ petitioners against the order also have not preferred any statutory appeal before the arbitrary appeal against the same. And as such, the question of any remedy at this stage is not warranted. Notwithstanding, next paragraph, it is this court is not a court of appeal against the order of removal, but only to examine as to whether due process has been followed. But however, with the impugned order not under with the removal order under challenge and the relief being claimed limited only to the question of the substance allowance for certain periods which are claimed, this writ petition do not interfering with order of removal is disposed of the direction that the writ petitioner has put in a representation with regard to the exact dates on which the claim substance allowance is not paid before the respondent authorities who shall consider the same for appropriate orders. Except on these on these directions as given above, the petition stands disposed of. Yes. Very unfortunate, Mr. Sabha. You're all young counsels, these things, juniors.
But you want?
That means you don't check.
It will not happen
when,
again,
You
Your
don't
Lordship.
check when they prepare it.
We realized it later only, Lordship. We apologize.
Especially when there's similar petitions, always better to minutely check.
Yes, Lordship, we'll do that.
Yes.
Thank you.
Yes, why objecting?
Lordship, in this matter, the state has to take instruction, has to bring the record.
Where's Mr. Harwana?
He's coming.
Absolutely. For next matter.
34.
May I please, Your Lordship?
Yes.
Your Lordship, this matter is related to the family pension, my lord. So here, Your Lordship, petitioner is the second wife of the late her husband Akam Loskar, Your Lordship, and she got married in the year 29/3/2011. This is Annexure 3, my lord, of the petition. Page number 17, my lord.
Now I think you are.
I'm the second wife, my lord. So after this is page number 16.
No, but see, the earlier case has come here which year? 22.
22, my lord.
And this order is passed?
22 itself, same day.
What happened to representations? Why not allowing the pension?
So they have not actually, never even, Your Lordship, it is regret that.
Yes, Mr. Pandey. As per the amended rules, as the post-retiral wife was entitled. Yes.
No, Milords, in this case, the Milords petitioner retired in 2004.
Right.
And in 2004, Milords, and the date on which he retired, the post-retiral wife was not entitled for family pension. It is governed by Rule 48(1) of the Meghalaya Civil Service Rules, Milords. So only in Milords 2010, an amendment in the rules have been made. The rules have been made applicable since 2007. However, in this case, the retirement happened 3 years prior to the application of the rules, that is in 2004. Therefore, the petitioner is not entitled to, Milords, in terms of the rules, not entitled. But interestingly, Milords, the first representation in this regard was rejected in 2009, which was never challenged.
Oh.
Again, Milords, 2009 petition is filed in 2025. Same issue, that the name has to be changed and the name of the new wife has to be incorporated. So, Milords, that your Lordship will find as Annexure 5 of the petition. 19th May 2009, which is at page 19. 19.
Yes.
So it says that, Milords, with reference to the above, I am to state that Rule 48(1) read with Note 2 of the Meghalaya Civil Service Rules 1983 provides that marriage after retirement will not be recognized for the purposes of family. Hence, your request for change of nominee owing to remarriage after retirement cannot be entertained. This never was challenged, Milords. And Milords, kindly sees 48(1).
Where is that?
Milords will find 48(1) in the reply affidavit that I filed at page 32. Rule 48(1).
Yes.
It says, my lords, family for the purposes of rules in this section will include the following relatives: wife in case of a male officer, see minor sons, unmarried minor daughters, so on and so forth. Now, my lords, next page, note 2, my lords. Marriage after retirement will not be recognized for the purposes of rules in this section.
There was amendment.
Yes, my lords, amendment your lordship will find as annexure 8, page 23 in the writ petition.
It says from Thorn 7.
Yes, my lords.
Where is that?
Page 23, 1, 2, my lords. Short title and commencement 2.
Okay.
They shall deem to have come into force on 1st day of January 2007.
Yes.
So, my lords, in the conspectus of the facts that are there in this matter, my lords, the entitlement of the petitioner as far as family's pension came to be, my lords, decided way back in 2004. And on that date, my lords, as per the rules available, my lords, the second marriage was not to be recognized.
No, whatever it is, but then the thing is that the fact that she's a post-retired spouse, is that denied? Yeah, I mean, that she's a spouse, legally married spouse, is it denied? How can you say it?
The question here is not, my lords, whether she is a legally married spouse or not. The question is whether on that date the second wife could be recognized, because the rules categorically say that whosoever are your legal heirs as on the date of the retirement, they will be recognized. And kindly see, my lords, thereafter again,
why did you challenge the 2009? Why coming? Why have you come so late?
Your Lordship, that was 2009. What it was actually, my late husband, he has written a representation to the department that my name has to be changed, substituted in the name of the previous wife. This is not for my pension. My claim has come up only after the death of my husband, Your Lordship. This is in 2016. That was his effort he has made. But thing is that in 2016, and moreover, Your Lordship, when 2016, after the death of my husband, I proceeded the matter. Thereafter, they have only replied, and their reply is there, Your Lordship. This is in page number 21, my Lord. I have sought an information sought under RTA Act 2005. This is dated 14/8/2017, my Lord. So they have replied with this, with reference to the letter. This is page number 21 of my writ petition, my Lord.
Yes.
So this is with reference to the letter under reference above. Please find here with the information sought under RTA Act 2005 as received from the Senior Accounts Officer Pension MECL Shillong. So here in the second page, next page 22, they have mentioned all these things, Your Lordship. So in the point number 4, furthermore, the information under RTA Act 2015 as desired by Srimati Jahanara Begum are furnished as under. Status of the application: the request could not be entertained as the name of the nominee cannot be changed as already replied
when did you remarry? 2009?
2009, Your Lordship.
Then?
Thereafter, my husband has made representation twice, but they have rejected on the ground showing that the 1983 these rules, Meghalaya pension rules, my Lord. But even then, Your Lordship, my case is covered by the judgment of the Honorable Dadan Meghalaya High Court. One judgment is there. This is on 2009, my Lord. Justice Baipai, he has passed, and even he said actually this is not required, my Lord. It need not to be challenged, this even pension rule also. This is very much dictated here, my Lord. Just give it. This is very clear. judgment, my lord. It is in 2010, my lord. 2010 1 Guwahati Law Reports 437 Shillong Bench, Justice T. Pai Pai. In Binalesa M. Sangma versus State of Meghalaya. So I want to actually take this honorable court in the paragraph 8 of this judgment, my lord. Oh, sorry, it is in reference to paragraph 7, your lordship, covering the Supreme Court judgment in Bhagavanti Supra. And later on also this honorable court has passed many judgments. Other judgments also 2024 judgments and some other reference also been made. So basing on that, your lordship, page number 442, I'm going just simply, here it is noted in paragraph 10 has been reflected here in the next page 442. Before of paragraph 10.
Paragraph 10?
No, sorry, paragraph 8 beforehand, middle of that. Only reference been made. When a larger bench consisting of 11 judges of this court in TMA Pi 2002-8 SCC 481 has declared what the law on the matter is, we do not want to dilute the effect of the
Where reading from?
442 page, my lord. This judgment 442. In the middle.
10, oh.
Yeah, it is a reference been made of the Supreme Court. This is 11 judges judgment, your lordship. So here it has been very clear, your lordship. Analyzing various statements made therein or indulge in any dissection of the principles underlying it, we would rather state that the state government shall take note of the declarations of law made by this court in this regard and make suitable amendments to their laws, rules and regulations to bring them in conformity with the principles set out there. And thereafter, in view of the matter, it is unnecessary to examine whether the present rules are valid or not, until such time as such rules are framed in terms of the order made by us now. The interim orders made by this court in this proceeding will be operative. And next, very interestingly, what's ruled here, in the case at hand, also I am not obliged to dismiss the writ petition on the technical ground that the petitioner does not challenge the validity of note 2 to rule 48(1) of the Meghalaya Civil Service Pension Rules 1983, since such challenge is not really necessary in view of the definite pronouncement of law made by the Apex Court in Bhagavanti Supra and Lakshmi Kanwar Supra in perimeteria provisions. In the result, the petitioner has made out a case for the interference of this honorable court. Nonetheless, there is one aspect of the matter which is disturbed my mind. Though the writ petition was filed in 2006, the hearing could not be...
This is before the amendment, correct?
Ji?
When was the amendment made?
No, amendment is on effected on 2010, my lord.
No, I mean this judgment was before the amendment.
Of course it is before amendment, but yes. Before the amendment, my lord. And after amendment,
one question, when were you married?
I was married in...
Where's the certificate?
Marriage certificate.
Nikah certificate you have?
Yes, my lord.
Where's that?
Marriage certificate is... Certificate is... Oh, page number 17, my lord. Page number 17 of the...
This is 11.
No, 11, but effected from this is 13/3/2009, my lord.
Yes, so Mr. Pandey, what's the problem?
The rules, my lords, 2009, and the petitioner retired in 2004.
So?
The question is not when he... So 2004 48(1) rule note number 2, my lords, was applicable. As on that date...
How do you qualify this argument? Post-retirement is post-retirement.
My lords, kindly sees 41(2) again. 41(2).
Yes.
48(2), my lords.
Yes. What does it say?
Plus 48(2) at page 33 of the affidavit in opposition, my lords, kindly sees. Marriage after retirement will not be recognized for the purposes of these rules.
Right. That's been amended 2010, but effective 2007.
From 2007. So retirement has already happened. I have to pass a pension payment. Kindly see.
So you have to say that it has to retire after 2007.
No, the pension payment. When will 48? When will the entitlement heirs will be decided under 48? That will be decided on the date of retirement, because payment of pension will start immediately after the retirement. So when pension has to be paid immediately after the retirement, the legal heirs will also be decided immediately after the retirement.
He did.
At the
He
time of
wasn't
retirement.
married at that time. I don't understand this argument really. We're talking about post-retiral spouse. A person retires, no matter when he retires, he marries again after 10 years. That she won't be entitled as per your rules.
Milods, for this rules 48, the department has to decide the legal heirs and pass a pension. Kindly sees the pension payment order. Milods.
Right. Now, okay. At that time, he might be still married to this first wife also, for all you know. Right. And then, okay, for some reason, wife dies, he marries again. Why should the second wife be deprived?
So, Milods, the pension payment order, which has been passed in 2004, has been passed based upon the rules.
Right.
And kindly sees page 14. Kindly sees page 14, Milods. Page 14 of the writ petition.
Right. Yes. Yes.
Page 14 of the writ petition, Milods. In the bottom, in the event of death of Shri A.K.M. Laskar, family pension of so and so must be paid to Gulshenara Begum Lashkar.
Yes.
So, and the date is 7th April 2004.
Yes.
So in terms of 48, section 48, the rule 48, this order has been passed in 2004.
Right. Fine.
And
now he married again 2009. So
2009 he marries again, but the pension payment order is already passed.
Doesn't matter. But the thing is, he married post-retire. She's a post-retired spouse, the petitioner.
No, but then it will be it's not a question of remarriage. It's a question of retirement.
I don't understand. Your submissions are making no sense, frankly. We are looking, just apply common sense now. He was married to someone else, when he was still serving. He retired, payment orders made. His wife was to be the beneficiary in case of his death, family pension. Now he outlives her, gets married again. So what is the difficulty?
So
and your rules allow that with the amendment after effective 2007. That means that he's entitled.
But the rules, Milods, will apply to the retirees which are retiring from 2007 onwards.
How show that? How do you qualify that? Yes.
Kindly see the amendment, Milods, the amendment which has been made.
Where is that? I think we're running out of time.
NGL 8, Milods, page 23.
Yes. See. Where's that note?
Page 23, Milods, of the writ petition is the amendment.
Yes. See, note 2, post-retired spouses, children born for retirement. The family pension is eligible to post-retired spouses and children born. So,
your Lordship has page 23 of the writ petition.
Yes.
It says, my lords, in exercise of powers conferred by proviso of 309, the government of Meghalaya is pleased to make the following rules to amend the Meghalaya Civil Services rules. So this amendment is coming into force, my lords. Rule 1-2, my lords, they shall deem to have come into force on the first day of January 2007.
Yes.
And kindly see, my lords, 48, the amendment to Rule 48.
Now they married in 2009. That's the case, correct?
Because as per my humble submission, because the date of marriage will be irrelevant. Date of marriage.
So he has to retire after 2007 to avail of this. Has to
be. In my humble submission, he has to retire after 2007.
I mean, yes, retire 2007 and then die. So his wife will get the post.
Die any time, Milods, thereafter till the time the rules are applicable. But the only thing is that let us assume, Milods, a situation where the rules are thereafter after 2007 taken away. Let's say in 2017 there is an amendment and I do away with the entire rule. Then, Milods, the benefit which have been granted to the person
in that
who
period
retired
up to 2017. Yes, we understand that.
So that is also an absurd interpretation if later on, by way of a further amendment, I take away that entitlement. So the ultimate question is not the date of remarriage. The ultimate question is, when is the pensionary benefit to be decided for a person who is about to be retired?
Just show me no
And
authority.
the answer
How we can extend this benefit. You show an
is,
authority.
then I'll produce certain authorities, Milos. Yes, I'll come
Yes,
back.
interesting
with
point. Yes. But this is a pension matter. You see, that's not done same
Because
footing.
I understand, I understand, because there are, but the petitioner has not even implemented the other legal heirs. There are 6 children.
But the thing is that, Mr. Chaudhary, you come to the court after a long time that we go against you. 2009, the auditor of challenge, you haven't done it. Just out of compassion, we are hearing this matter. Otherwise, on the ground, delay will be dismissed outright.
After 16, actually, my right has been accrued, my lord. And I have a.
Why not reject it? It's not the question, it's a continuing cause of action away. It was rejected at that point of time for introduction of wife's name. Should have come to court. Nothing was done.
But she has no children even. She has
Just
no.
a matter of further hearing after 1 week. Mr. Pandey to come up with authorities. Yes.
31.
Obliged.
Yes. Where was Kharwan Lang? It disappeared again.
Worship is here only. Worship, in this matter, as per the order dated 12/6.
Where's call him? Where's he?
He went to call him.
Mr. Qureshi, any urgent matter?
Roshi, one matter is the item 37.
Yes.
38.
Matter has become infectious.
How you become infectious?
Then I will explain.
Yes. Oh, MS Rahman, now you go to tomorrow.
This is the.
Why not waiting in the court with Kharwan Lang? So important that you attend to the matters, next matter to be checked out. Utter disrespect to the court. If your matter was passed over just because you're not here, and then you don't bother to sit and wait also.
No, I was watching from YouTube and all. Doing some research on my apologies.
Lordship, this is the case of.
Yes, we'll take up the case. Yes.
This is the case. I'm the lowest bidder.
Wait. Matter. Okay. Your matter we will after 1 week.
After 1 week.
Yes. No time today. We have a meeting also. Yes. 37 after 1 week.
I just that matter where my lord was hearing the pension matter. My lord is covered by my lord's judgment, Hosila Sangma, where the lady has married after the man got retired. So it is similar, I feel, my lord.
Yes. What instructions do you have?
My lord, I'm still yet to receive the report.
What report?
My lord, as per your lordship's order.
Matter regarding what?
My lord, this is regarding the petitioners are alleging that.
Pharmacists.
Pharmacist.
Yes,
we have challenged the recruitment process, my lord.
When can you produce the records?
Lordship.
My lord.
Advertisement was. (19/7/2024) advertisement dated. Lordship, hearing this matter,
But the selection was on 24.
Yes, bro.
Lordship.
Challenging it now.
Yes, bro.
No, Lordship, we have filed the petition on 24 itself.
Oh, 24.
24.
Yes.
My lord, can I take your lordship's prayer?
No, you produce the records then.
Yes, my lord, but.
Lordship, as per the order dated 12/6/2026, they have to produce the record, the address of the private respondent in the application form.
My lord, the petitioner is asking for this the state government to publish a district-wise selection list. My lord, we're
not going there as yet. Just see the records first.
Yes, my lord. My lord, I'm just coming to the crux of the matter. My lord, we have published a merit list, but then the petitioner wants a district-wise merit list.
Lordship, as per the advertisement, it was a district-wise breakup.
No, my lord. My lord, can I take my lordship to the advertisement? My lord, it just shows the post of the district will be filed by the candidates belonging to the particular district as declared by them in the application form. My lord, then the next line comes, in case with the no eligible candidates.
That district, yes.
No eligible
If her
candidates,
case
my
that
lord.
he is eligible from that district, he was not considered.
He was not eligible, my lord. He was not eligible,
show
hence he
that.
was not, my lord.
With
I can-
affidavit.
My lord, my affidavit is that is already filed, my lord. But my lord, I can just take my lordship through arguments from the
Lordship, no
annexures.
cut-off mark was given. I was called for the practical exam, and the candidate which got the post for the West Carroll Hills is 60, and my mark is 58.
My
How
lord,
come they can decide?
Doesn't, but then he didn't know, he was
Okay,
not
one thing,
eligible.
other records are available.
I still haven't received the records, my lord.
Yes, okay.
But then, my lord, I can argue from.
Lang was allowed time to produce the records by order date 1/7/2026. Today also he submits that record not received. This is a matter of 2 weeks. Next day expected. The record should be with the government.
Lordship,
advocate.
and the-
We'll like examine it.
Lordship, and the filling out the form has done through online mode. Soft copy has to be there.
Yes, my lord. But then my only argument is that if the person did not qualify, my lord, how can he ask
Let the
for
records, the
this?
records will speak.
Lordship,
Yes.
Much obliged.
obliged, my lord.